reports. It's not immune from a legality, from scrutiny on the basis of legality, and it's not immune from scrutiny on the basis of irrationality. So we accept that. To the extent that we may have been misunderstood, or we may have been understood to say that, to suggest, in fact, that even if the court found that the decision of the minister is not rational, it may not interfere with that decision. That's not the proposition that we are making, my lady.
So there's a clear recognition of the separation of powers. Is that the minister? Yes,
absolutely.
Minister's decision is subject to scrutiny.
Absolutely, right. My lady.
Sorry to disturb you. I just need to give notice to everybody that I do have the YouTube link available now. If a notice can be given out that all the public members are now to check on the message group. I'm going to post a link on there, and from there they may access the proceedings via YouTube.
Thanks. So, Sophia, so you've said it now in English, and I'm going to ask the gentleman if he could repeat it in Portuguese. I can't hear the gentleman in Portuguese. Sophia, you can put it up on the screen in the meantime.
Talvez para informar que a informação que estava a ser partilhada é de que já tem o vídeo disponível, o link disponível para poder se acompanhar no YouTube, em vez de estarmos a acompanhar aqui no Microsoft Teams. E o link vai ser partilhado aqui no chat. É só prestar atenção no chat e vão ter o link disponível, e pede-se que podem aceder a audição através do link que vai se partilhar no chat do YouTube. Thank you.
Thank you. So, Sophia, if you could put that address, that YouTube address, and we'll give parties at least 2 minutes to write down that address.
Okay, I've just pasted it onto the messages. They can even access it via the messages immediately. They just need to click on the link.
Gentlemen in Portuguese, could you just repeat that? That all they need to do is click on the link as it is on the screen now to see it on YouTube.
O link já está a ser partilhado no chat. O que devem fazer para poderem aceder é só clicar no link e vai vos levar diretamente para o site no YouTube para poderem acompanhar.
Sophia, I don't see the address on anymore. It seems to have gone off.
It was on the messages. Let me just repaste it.
I think repaste it.
Yeah, okay, there we go. Okay, it's been repasted, and from now I'm going to start removing the public and stop accepting anybody coming into the meeting.
Okay, do you think everyone's had enough time to write it down?
No, if we could just give them about 5 minutes to join that link as well.
All right, so Ms. Beloy, I think I'm just going to mute for a few minutes.
As your ladyship pleases.
right.
Also, yes,
Just put
after,
it up again.
okay, after 1 o'clock, I'm going to start removing everybody from this meeting.
Right.
We have to stay online. No, I'm saying, could we not, my lady, if I may ask, would it not be easier if we all just got off the platform?
I think so.
And then
Just let us in.
Yes.
Sophia, did you hear that?
Yes, my lady. So can I end the meeting and then we rejoin?
Yes.
Only the members that need to be on the meeting.
Right. We could do that. So we're all leaving.
Yeah, Judge, I'm just going to leave at 1 though, just to give everyone an opportunity. Can everybody please take the link for YouTube and then move on to that platform? Councils, Ms. Puriffin-Jones, I'm just giving everybody till 1 o'clock and then I'm going to end the meeting and reopen it. So please give me till 1 o'clock and then rejoin the meeting.
I'm present, my lady.
Yes, I am.
Right. So, Ms. Beloy, if you could go ahead, thank you.
As your ladyship pleases. Yes, as your ladyship pleases. Yes, my lady, I had already made the point that there is no, we don't make controversy. That
Sorry, Advocate Beloy, I just need to record. My apologies for disturbing.
That's all right.
Okay, you may continue.
Thank you. Thanks, Sophia. So, my lady, perhaps just to recap, there is no controversy that the decision of the minister is not immune to scrutiny for rationality and legality. We accept that position of law. To the extent that we may have been misunderstood or understood to suggest otherwise, or to make a proposition otherwise, the point that we are making about it is that in the scrutiny of the decision of the Minister for Rationality and Legality, when that is done, it is not the opportunity to impose the preference of the court on the minister or in the place of the minister. That's all we are saying, my lady. So it's not he ought to have done this as if it's an appeal when his decision is being scrutinized. It is not that. The inquiry is his decision rationally connected to the purpose of his power or to the power that he is given by statute. It's simply that. And for that, one has regard, we say, to the evidence that was before him, what were the facts that were before him, what are the reasons that he provides for his decision, and then you evaluate whether he has met the rationality test. And this point, my lady, is, I think it is important to make, especially in the light of the submission from my learned friend for Helen Suzman Foundation, who says the minister ought to have done this and that on immunity. Exactly that point that we are quarreling with, that is not the standard. The standard is whether what he did, given the evidence that was before him and the reasons that he has provided, do they pass the test of rationality and legality? It's simply that, my lady. The second issue, my lady, that we do not take quarrel with or that we do not create controversy about is that it's about the applicable legal framework that binds South Africa in considering an application such as we have presently, or such as the application to extradite Mr. Chang. And, my lady, in the heads of argument, we have, as the other parties have done, referred to the Extradition Act as applicable. We refer to the SADC Protocol, to the US Treaty, the Constitution, and international law and instruments that are binding on South Africa. We accept that. But for clarity, my lady, to the extent that some of the submissions, especially of the Helen Suzman Foundation, seem to suggest that the minister may well consider himself or South Africa not bound by the instruments that obliges the fight against corruption. My lady, that's not the position of the minister. The minister accepts that.
Now, let me ask you this, Ms. Bloy. You say that once the decision is rational and meets all the elements of rationality, then in that event, the court can't impose a preference on the minister.
If you find that, yes. If you find the decision is rational.
Yes.
You may not impose, your ladyship may not impose a preference. Yes, that's simply all we are saying. And so the second issue, my lady, as I point out, that we don't make controversy about is what is the applicable framework that is binding on the minister when he's called upon to exercise his statutory powers in a case such as the present. And I will not, to the extent that, for purpose at least of this submission at this point, I would not get into the detail of what those instruments are. We set them out in our heads of argument. The third issue, my lady, that that there's no controversy about is that the minister, in exercising his powers, must and is obliged to have regard to all relevant factors that are before him. And if he fails to consider or to have regard to a material relevant factor or fact, that indeed may well be fatal to his decision. If not, it is fatal. It would be fatal to his decision and render it liable to be set aside. So we accept that he must have regard. He is obliged, as a matter of law, to have regard to all the relevant factors that are placed before him, especially material factors. So my lady, that's the premise from which we move. And when I discuss the various grounds for review, my lady, which I submit the roadmap for the court evaluating the rationality, legality of the decision of the minister. It's the grounds relied upon by the applicant in its review application. So the evaluation doesn't occur in a vacuum. One has regard to what are the grounds, and in respect of each ground, what was before the minister, and what are the minister's reasons for deciding in the way that he did. And what I'll then do, my lady, is I will then, in discussing the various grounds for review, show your ladyship that in fact there is no merit in most, if not all, of these grounds for complaint, and I will do so under each heading, my lady. Now, my lady, it's important to make the point that this application, sight should not be lost of the fact that this application concerns a request from two countries, both of whom have been prejudiced by the alleged conduct of Mr. Chang, and there cannot be any dispute or quarrel about that. And one need only have a look at Chang 1, where that court sets out the impact on Mozambique of the consequence of this conduct, of the alleged conduct, and specifically what the court in Chang 1 points, and I think it's at paragraph 6 of the judgment, my lady, is that in fact Mozambique has been burdened with having to repay loans up to, I think it's a sum of about 2 billion rand that was involved here. It's been burdened with having to repay those loans. And two, as a result of this conduct, donors have either withdrawn from providing funds to Mozambique, or they have reduced their donations or support for Mozambique. And the consequence of that is not only on the government of Mozambique, but also on the people of Mozambique themselves. That's recognized in Chang 1. In respect of the United States of America, and of course that is recognized because that is what would have been put before the court by Mozambique. Similarly, in respect of the United States of America, what is recognized in Chang 1 and is not controversial is that the harm caused or for which the United States seeks to hold Mr. Chang liable is the loss of American investors, financial loss caused to American investors by the alleged schemes in which Mr. Chang is said to have been involved with others. And then two, the use of the American or the USA financial systems to perpetuate or to perpetrate the alleged money laundering, securities, fraud, and all of that. So those are the competing reasons why these two countries seek Mr. Chang to be extradited to their respective countries. The applicant obviously and unashamedly asserts that it prefers for him to be extradited to the USA. That is its preference. And the Helen Suzman Foundation further complements that and says, well, the reason you want him to be extradited to the USA is because he will not be effectively, and that's also what the applicant says, will not be effectively prosecuted in Mozambique. Now, my lady, we have dealt in the minister's answering affidavit with the grounds for review relied upon by the applicant. We did not have the opportunity to deal with what is set out in the affidavit of the Helen Suzman Foundation. And this is so because, firstly, Helen Suzman Foundation is cited as a respondent. So they supposedly sit on the same side as us, notwithstanding that they make common cause with the applicant, as it turns out. But at a more for practical reasons, or a practical reason why we haven't been able to deal with that, is that the affidavit of the Helen Suzman Foundation was uplifted on case line on Tuesday the 14th at night. It wasn't served on the parties, at least not on the party that I represent. And when we became aware of it, if we wanted to respond to it, or if there were opportunity to respond, the likelihood is this hearing would have had to be deferred, notwithstanding, my lady. And I raise that to the extent that your ladyship may have regard to that affidavit. This is a matter of concern that I would like your ladyship to keep in mind. However, what we've done in the heads of argument is we have dealt with the submissions of the applicant, and to the extent that there is commonality between the applicant allegations and the Helen Suzman Foundation's allegations in the affidavit, our submissions hold for both, my lady. But this only holds, or can only hold, to the extent that the Helen Suzman Foundation doesn't make any factual allegations that we didn't have the opportunity to answer. And if it does so, my lady, I would ask the ladyship to keep in mind, or to be mindful, that we hadn't had the opportunity to answer whatever allegations, and we should not be deemed to have accepted and not challenged those. Now, my lady, perhaps let me proceed then. I have said that there's no controversy about the legal framework, so I will not delay with that. And I will go straight to the grounds for review, because you must see from the grounds for review whether the decision of the minister indeed suffers the deficiencies that the applicant contends it does. Now, the first ground, my lady, that I would address is the complaint that the USA's extradition request enjoys temporal primacy. And this complaint, the complaint, and I note, my lady, that my learned friend, Mr. Duplessis, and he must forgive me if I misrepresent what happened this morning, but I noted that he didn't speak to it, but I assume that it is a point that he persists in.
Yes, I don't think much was made of that, Ms. Benoy, of the temporal sequence.
Yes. And my lady, I only mention, and perhaps it's sufficient, my lady, to then say that we stand by the submissions that we make in the written heads of argument, which is there is no law whatsoever that gives the United States preference, or the application of the United States preference, solely by virtue of the fact that its application was first in time, my lady. And they haven't pointed us to any law other than to, in fact, they do acknowledge, the applicant does acknowledge that this is one, while it asserts that because it was first in line, that's one of the factors why it should have been preferred. They do accept in their submissions to the minister that, well, this is just one of the factors that the minister must take into account. And we agree that with that correct position. The second issue, ground for complaint, my lady, is the immunity of Mr. Chang. Mr. du Plessis calls this a killer point. I agree with your ladyship that if in fact, on the evidence that was before the minister, it turns out that Mr. Chang continues to enjoy immunity, if that's what the evidence that was before the minister points to, then I accept, my lady, that it is what Mr. du Plessis calls a killer point, right? Your ladyship wouldn't even have to look at the other factors, because as in Chang 1, if he enjoys immunity, then he's not extraditable he's not liable to be surrendered.
Is his immunity still not equivocal at this stage?
My lady, we submit that on the evidence that was before the minister, and I'll take your ladyship through the opinions that my learned friends represent different from how we understand them. It is not equivocal. That's the position of the minister. He accepted that on the opinions that have been procured, it is not equivocal. But in addition to the opinions, my lady, the Mozambican government also in the submissions said he doesn't enjoy immunity, and Mr. Chang himself said so. My lady, and perhaps on this last point, I should perhaps dispose of the unsubstantiated speculation which my learned friend for the Helen Suzman Foundation makes, but Mr. du Plessis also makes elsewhere, that, well, Mr. Chang would prefer to be surrendered to Mozambique on the expectation that he will get lenient treatment when he's there. My lady, there's absolutely no basis, in fact, at least. There's no basis, in fact, for those kind of statements. It's no more than the suspicion. It's no higher than a suspicion of the applicants and of the Helen Suzman Foundation that if he is surrendered to Mozambique, he will get treatment, he'll get leniency. In fact, they go so far as to say he will not be prosecuted. Now, that's not based on any fact. And your ladyship should not have regard to that. Your ladyship should have regard to what was what was before the minister when he determined that he will accept the submissions of Mozambique and Mr. Chang about the status of his immunity. And before I take your ladyship to the memorandum, and I know, my lady, there's the controversy about the memorandum, the internal memorandum, and I'll have to deal with that. But for present purposes, if your ladyship would permit me to just deal with what is being said about it. Now, firstly, nowhere in the minister's affidavit does he say Mr. Chang has immunity. That is simply not true. It's not correct. And it would be quite shocking that the minister would say that and still, when he in fact has decided to surrender him to Mozambique, considering that in Chang 1, that's exactly why he went to court. He went to court in Chang 1 because he said, on what he sees, what he's come to see, Mr. Chang enjoys immunity. That's Chang 1. He enjoys immunity, and for that reason, he went to court to get the decision of his predecessor set aside. Would be indeed strange that this time around he would, notwithstanding that, in fact, put it on affidavit and say he does have immunity, but my decision to send him to Mozambique was rational. Well, that goes against the letter of the SADC protocol. Nowhere, my lady, nowhere in the affidavit does the minister say that. And my lady, I don't mean to refer your ladyship now for it, but the reference is, your ladyship will find that at section 06, so it's 06, page 188, and that's the minister's answering affidavit. And he states what the position is about Mr. Chang's immunity. None of it is that he enjoys immunity, or that the minister accepts that he enjoys immunity. And it's simply misleading for my learned friends to suggest that that's what, to propose to your ladyship, that that's what the affidavit says. So the minister's position is he accepted that Mr. Chang does not enjoy immunity. Now, my learned friend for the applicant says that but the minister disregarded, he took opinion. That opinion, all of those opinions, except for one, tells him that Mr. Chang enjoys immunity, still enjoys immunity, and therefore he would invoke immunity if he is surrendered to Mozambique. My lady, that's not what the record shows. On any reasonable in fact, on ordinary reading, without straining, that's not what that memorandum states. And if your ladyship would bear with me, that I take your ladyship through that. Mm-hmm. My lady, the memorandum is at section 6 from page 205. And I will try to do this quickly without taking too much of your ladyship's time about this.
Thanks.
My lady, if I can just first learn how to get there. I'm trying to get there to you.
I'm also confused. One of the clerks showed me a shortcut.
Oh, I should learn that. So, my lady, the memorandum starts at page 206. So it's 06-206.
Right.
And the references, my lady, there's quite a number of them. And your ladyship goes to, so that is the memorandum. And if your ladyship firstly goes to paragraph 7.5 of that memorandum.
Right.
If your ladyship would bear with me. Now, where paragraph 7.5, perhaps for context, my lady, this is an opinion. And my lady, we have redacted the names of the persons that gave those opinions, and the minister explains that. I think we do explain in the affidavit that to protect their identities, we have redacted their names from the opinions. Now, that is one of the legal opinions obtained. And in 7.5, after summarizing above, 7.5 reads, it appears that the Mozambican request no longer suffers the defect that Mr. Chang enjoys immunity from prosecution, and a possible decision in favor of Mozambique can therefore not be unlawful, okay? Provided that the minister also considers all factors contained in the SADC protocol and in the USA treaty. These factors some favor but also disfavor the Mozambique request. But for purpose of this submission, my lady, there's a one opinion. It firmly, and this is not a Mozambican expert opinion. And perhaps, my lady, for purpose of my submissions, let me just to clarify that there are three opinions. There's a total of 5. 2 are from experts in Mozambican law, and 3 are South African lawyers. And the one that I've just referred your ladyship to is a South African lawyer, counsel. And the next one, my lady, if your ladyship would just go back to 7.4 in the same document. And for context, my lady, this is another opinion. Your ladyship will see at page 06230, there's paragraph number 7, and it says opinion by. So this is another opinion. And what your ladyship finds at paragraph 7.4, it says no more than this. It says it is extremely important to note that it is clearly indicated that the above mentioned view cannot be confirmed. In fact, perhaps, my lady, let me, for completeness and context, let me start in the preceding page. At the bottom of the preceding page, my lady, you find your paragraph 7.2, and it reads, the most important question is whether Mr. Chang still enjoys immunity, because if he still has immunity, the High Court judgment is a bar, and this is a reference to Chang 1, is a bar to the minister agreeing to the request from Mozambique. And that's exactly what I said at the outset, that if the minister recognized that. And then 7.3 reads, the view is held that according to the representations of Mr. Chang and Mozambique, Mr. Chang no longer enjoys immunity. And this is based on the assumption that the immunity stopped to be of effect the moment Mr. Chang was no longer a member of parliament, which would then also mean that the immunity in terms of Article 174 of the Mozambican Constitution is no longer applicable. Now, this is what the Mozambique and Chang had submitted to the minister. And this opinion writer then says in paragraph 7.4, it is extremely important to note that it is clearly indicated that the above mentioned view cannot be confirmed. That is the view of Mozambique and Chang, confirmed by case law and the lack of the law of Mozambique, and no advice can therefore be given whether immunity still exists or not. Just there, my lady. So this opinion writer, and this is a second writer, it doesn't express an opinion that Mr. Chang enjoys immunity. I am mindful in my submissions, my lady, that the submissions of Mr. Duplessis and my learned friend for the Helen Suzman Foundation, that according to these opinions, Mr. Chang continues to enjoy immunity, are made without pointing your ladyship to any provisions in this memorandum that discusses their opinions to confirm their assertions. But I have referred your ladyship to what this second opinion says. So no view is expressed. And then in the next sentence, the writer says what Mr. Duplessis referred to. He says, as will be indicated hereunder, it might, doesn't say you must, he says, it might therefore be a good idea to consult with the FMO, who will most probably be in a position to address this issue. And then he says, the discussion hereunder is, however, premised on the assumption that Mr. Chang no longer enjoys immunity. There's an assumption. Now, my lady, that second sentence to speak to FMO, firstly, the minister is not directed, and of course he couldn't be. The writer of the opinion doesn't assert any basis for the minister to consult with FMO. But more importantly, my lady, the applicant, that's FMO, is not an expert in Mozambican law. It doesn't describe itself as an expert in Mozambican law. So the suggestion, the proposal that it should speak, that the minister should confer with FMO on the matter is irrelevant completely, because they are not. But importantly, my lady, in these proceedings, the applicant itself, it places the question no higher than there's a possibility that he enjoys immunity. And in the submissions that are made, that he does enjoy, in fact, if that is a submission, well, it doesn't accord with the submissions made by the applicant to the minister, but also in their papers before your ladyship. They do know more, and they cannot do, well, maybe they could have obtained expert opinion, but they do no more than to say it's a possibility. Now, your ladyship must juxtapose that. This submission that was made by FMO to the minister, by the applicant to the minister, that there is a possibility, must just juxtapose with the firm views that are expressed by Mozambique, that are expressed by Mr. Chang, and as I will show, that are expressed by the other opinion writers, the legal experts in particular. So it is not, so we've looked at the second opinion, my lady, that he which doesn't say what my learned friends submit their opinions do. And then, my lady, at 7.5, that we're still dealing with that same opinion. I have already referred to that it appears that the application doesn't suffer from this anymore. And then if your ladyship on the same document would go to, it's still the same opinion, if your ladyship would go to paragraph 7.8, it is the conclusion. And it says, and it speaks much more firmly than the applicant does on this issue. It says the extradition of Mr. Chang is a possibility in terms of the High Court judgment, accepting that the factors as are contained in the SADC protocol and USA treaty are considered, and the fight against corruption will be served with the decision. Now, this opinion writer would not conclude this way if they had expressed a view in the opinion that he still enjoys immunity. So it is not correct that this opinion advises the minister that Mr. Chang continues to enjoy immunity. My lady, the next opinion is in the very next paragraph. Your ladyship will see, and if your ladyship would consider, is I have made the reference to paragraph 8.2, my lady. And it reads, it is clear that the only defect to the Mozambican request was, that's in the past, my lady, was the fact that Mr. Chang enjoyed immunity to prosecution at the time the former minister made his decision to extradite to Mozambique. And this is due to the mandatory grounds for refusal contained in Article 4E of the SADC protocol, historically. And that's correct. At the time that the minister, as Chang Wan found, the court in Chang Wan found, he enjoyed immunity. And the next sentence in that paragraph, it says, if it is accepted that Mr. Chang no longer enjoys immunity, the minister can also consider the Mozambican request since certain circumstances have changed from the time the former minister made his decision. And then in the next paragraph, the writer sets out that the minister must also consider other factors, whether Mozambique is committed and able to effectively prosecute Mr. Chang for the crimes committed. Linked to this aspect is also South Africa's obligation to fight corruption, and a decision in favor of Mozambique must be in line with this obligation. Now, in the conclusion, importantly, the writer of this opinion says, in conclusion, it is stated that granting Mozambique's request will not breach South Africa's domestic law, but that it is still possible that even a lawful decision may give effect to a review application by a disappointed state. That's the nature of the beast, my lady, that even the best of decisions do end up in the courts, even though they have no merit. But that in itself is no indicator that the minister knew at this point, or when he made his decision, that his decision is flawed because Mr. Chang enjoys immunity. The writer of this opinion, in fact, says the contrary. He will not be in breach of South African law if he surrendered Mr. Chang to Mozambique. My lady, the next opinion, and this is the first expert opinion, my lady. And perhaps, and my lady, as I do this, and just so that I do not forget to address it briefly, that the suggestion that the minister latches on to one opinion which is favorable to his biased position, when the other opinions are against him, in fact, if it serves only one purpose.
Sorry, Okay, you'll have to mute.
You may unmute.
Right. Ms.
I think
Beloy,
Sophia,
if you could
yes,
repeat that submission.
yes, my lady, I was saying that in fact, before I deal with this fourth opinion, let me perhaps, now that I have it in my mind, respond actually to the submission that the minister selectively, and because he is biased, has attached himself to the fifth opinion, which is the only opinion that supports his bias to send Mr. Chang to Mozambique. I have illustrated, my ladies, so far that the three opinions do not say that Mr. Chang enjoys immunity. In fact, those that express a view, a positive view or a firm view, they say it doesn't appear that he enjoys immunity. So there is no basis whatsoever for that criticism of the minister. It's a gratuitous criticism which is not founded on anything that is before your ladyship by form of the record, or what the parties have played, what the applicant and the Helen Suzman Foundation have placed before your ladyship. Now, this opinion, my lady, this is a further opinion, and if your ladyship would have regard to paragraph 9.3.
Right.
Yes, and this is the fourth opinion, and this is an expert opinion, someone who's an expert in Mozambican law. And what it says in 9.3, my lady, it says, name redacted, it says, is of the view that the extradition request by Mozambique failed to explain the deliberations and resolutions of the Mozambique Assembly Committee and had consented simply to a detention pursuant to a warrant. The permission granted by... If your ladyship would bear with me, I think I've referred to the wrong paragraph. It doesn't address what I seek to. Oh. My lady, let me perhaps for now move on to... Oh, yes. My lady, if I may do that. Actually, on the same paragraph, yes. My Leonard Jr. points out that it is the last sentence that I'm looking for. So in this opinion, if your ladyship, at that page 06233, where you have that paragraph 9, if your ladyship would start right at the bottom, the third line from the bottom where the name is redacted, and it says, name further states that as the accused is no longer a member of parliament and no longer enjoys immunity, he may still enjoy the privilege of refusing to testify on any information acquired by him in the exercise of his rights and duties while he held office as the Minister of Finance. In conclusion, name states that the procedures followed by the committee, and this is not relevant. Now, what this expert does, my lady, he says, so how the expert is summarized is that he states that he no longer enjoys immunity, member of parliament immunity. It's a different issue that he may refuse to answer questions on the grounds of privilege, but that is nowhere close and near to immunity. We are dealing with the criticism that he enjoys immunity. So this is not, the criticism is not supported by this opinion, certainly. And my lady, for completeness, I have to read so that I do not read selectively. 9.4, simply for completeness, my lady, is on the issue of concurrent requests. Name states that international agreements are always entered into, notwithstanding prior international commitments, rights, and duties of parties. Subsequent agreements with a third party can therefore never alter or derogate from preceding undertakings made with different parties. Consequently, undertakings made by South Africa in the SADC protocol, which came into force, cannot dispense South Africa from its duty to aspects and fulfill the extradition treaty with the US. My lady, before you, it is not the proposition of the minister in his affidavit or in the submissions that the protocol, the SADC protocol, had the consequence that it displaced the US treaty in importance. Now, in paragraph 9.56, my lady, the author concludes, it says 9.5 says, name concludes by stating, and if your ladyship goes to paragraph 9.5.6, it says, although the accused no longer enjoys immunity as a member of parliament in Mozambique, he still enjoys a right to refuse to testify on matters pertaining to tenure as a government minister. Of course, we know that he may refuse to testify, my lady, doesn't mean that he cannot be prosecuted and be found guilty of the charges. So this expert expresses the view that Mr. Chang doesn't enjoy immunity. That's what was before the minister. And lastly, my lady, the fifth opinion, again, and this is the opinion that my learned friends say is the only opinion that supports the minister's biased preference for Mozambique. And if your lady, I will refer your ladyship only to paragraph 10.5 of that. And what it does, my lady, in fact, my lady, let me do, because I am addressing the broad unspecified allegations that the submissions that these opinions, they say, they tell the minister that Mr. Chang enjoys or may possibly still enjoy immunity. Let me perhaps not be too quick to skip from here. This opinion at 10.2 states, it summarizes, although the Constitution of Mozambique accords members of parliament and judges immunity with regard to civil and criminal matters for acts committed during their term of office and within the exercise of their powers made, such immunity does not cover acts and omissions which are not related to their mandates or any such acts that are not committed in lieu of the execution of their functions attributed to members of parliament or judges. I will ask your ladyship not to make anything of the flippant statement that the minister has in fact just copied even the mistake. Well, that doesn't make his decision reviewable to the extent that it's necessary to mention that. But what this paragraph tells you, my lady, is that this expert on Mozambique law says, like judges and members of parliament, when they leave office or when they commit acts which are not in accordance with their mandates, they are not protected. The next paragraph, my lady, in fact, my lady, the next paragraph is 10.3, which states people, and this is a different point, we'll deal with this, my lady, in a different context. So I will skip it for now. And if your ladyship looks at paragraph 10.5, in fact, the whole of 10.4, my lady, up to 10.9, is actually quite useful in the way that it is formulated. And I'm surprised that my learned friends, well, I suppose they accept that's what it says. So they're not misunderstanding this opinion. But if your ladyship looks at 10.5, 10.5, the question was asked or is posed: what happens to the immunity once the member loses their membership of cabinet or parliament? Does the immunity they enjoyed as members automatically cease to exist, or they have to be lifted before they can be arrested, even after leaving or vacating office? And the answer is an affirmative, is an unequivocal rather. Immunity ceases automatically and immediately when the mandate or term of office is reached. And as your ladyship said correctly with respect, my lady, in the case management meeting, that well, the opinion could well be wrong. But this is the opinion that was before the minister, and it's true and correct for all the other opinions. And all of them, there is none of them that says Mr. Chang still enjoyed immunity. So the information that was before the minister, when he accepts that Mr. Chang, the submission of Mozambique and Mr. Chang, that he doesn't enjoy immunity, when he accepts that, there's no irrationality in that decision to accept that. So, my lady, this ground for review must obviously fail, because it is not supported by anything that was before the minister at the time that he made his decision. And my lady, the next ground for review that I will deal with, I'll skip a bit and I'll come back later to the one that I've skipped, is the criticism that Mozambique has acted in bad faith. Now, if your ladyship has proper regard with respect to this criticism, how it is formulated in the papers and in the submissions, the bad faith that is raised, and the minister should have had regard. In fact, my lady, it's not even he should have had regard to it. It is, well, he should have refused, because he does have experience with them, that they are not to be trusted. So it's a case of you're dealing with a state, a sovereign state. What is being proposed, my lady, is, well, once damned, forever damned. That's what really the proposition is you previously misled South Africa and said Mr. Chang doesn't enjoy immunity, and we've established that it wasn't correct what was put in the court dealt with that in Chang 1, that was not the correct position. But what the applicant and the Holland Suzman Foundation are saying is that, well, with that is a sign or a mark of bad faith on the part of Mozambique, and this should have made the minister more cautious in this time around. Now, my lady, that proposition disregards or seeks to disregard the obligation of the minister when he now makes a decision to deal with the facts as they now are before him, as they're presented to him at the time. So the facts that are presented to him, we know, that are presented to him this time around, is Mozambique says Mr. Chang is no longer a member of parliament. He doesn't enjoy immunity. As a fact, we know that Mr. Chang himself says, I'm no longer a member of parliament. And my learned friends are not saying, and they cannot say, that, no, it's not true, he's a member of parliament. So the premise of Mozambique's and Mr. Chang's submission to the minister is, no longer being a member of parliament, he doesn't enjoy immunity. He's lost immunity, so he's prosecutable. They say that. I've shown, my lady, that the opinions, in fact, speak to similar effect. And so that previously Mozambique had represented in Chang 1, in what culminated in Chang 1, differently, in the light of the new evidence or the new facts that are before the minister, I submit, my lady, that it couldn't be. In fact, if the minister said, well, you've once misled me, I'm not going to have regard for these new facts that you're now putting before me, that he's no longer a member. I'm not going to have regard to the opinions that tell me that he doesn't enjoy immunity. In fact, that alone would render his decision reviewable, because he would have disregarded relevant facts that were put before him. Now, so my lady, the Chang 1 happened. It had its own consequences. And it's simply a bad proposition to make that, because it happened previously, the minister this time around should have said, well, you are people of bad faith. I'm not prepared to give you, to surrender this man to you. So that's the first answer, my lady. But perhaps related to that, it's important also, my lady, to be mindful that the court in Chang 1 does not say that the representation that was made by the Attorney General that Mr. Chang does not enjoy immunity was made in bad faith. The court in Chang doesn't do that in Chang 1. It doesn't. So this construct that that was a sign of bad faith. Yes, the minister himself, as my learned friend says, that the minister was obviously unhappy that representation was made, and he says they misled the minister or his predecessor with a statement that Mr. Chang didn't enjoy immunity. But the court didn't find that was a result of bad faith. It didn't. So the bad faith construct is a construct that is made by the applicant and by the Helen Suzman Foundation in these proceedings. And Malaria submits that there is no factual basis for that. The further reason that, according to the applicant, or the further fact, according to the applicant, that indicates that Mozambique is in bad faith, is that Mr. Chang is sought by Mozambique for purposes of being a witness in a trial against other persons. And your ladyship, this is said in the supplementary affidavit of the applicant at page 11 to 18, paragraph 50 to 52. Now, my lady, that's quite a selective representation of what in fact Mozambique says. They pick and choose as they have done with the opinions. It's selective. What in fact Mozambique says is he is to stand trial, but we also need him to testify against other witnesses, because if we do not have him before our courts, then it hobbles us against the other witnesses. So it's a dual reason why Mr. Chair, at least that's what Mozambique puts. There's two reasons. It is he is to stand trial for the charges that are set out in the indictment, and that he would assist Mozambique. In fact, the prosecution wants him to testify against the other people. So, my lady, it is not correct that he was sought to solely to be a witness. In fact, my lady, I submit that it's completely irrelevant that he is also sought to be. It is at best completely irrelevant, but in fact, perhaps makes a further compelling reason why he should go to Mozambique. And my lady, we do set out we deal with the issue fully in our written submissions. And my lady, with all of these, so far, I submit, my lady, so far, that there is nothing in this criticism and what was before the minister, which renders his decision liable to be set aside on the grounds of irrationality or illegality. The next reason given is the minister has failed to provide reasons or other ground for the delay in making his decision. My lady, I need not detain your ladyship long about this. We make a simple point that this is not a valid ground for review, at least not for your ladyship. Now, the next ground that I would like to deal with, my lady, is where the applicant asserts that the interest of justice, this is another ground for review, demanded that Mr. Chang be extradited to the USA. Now, my lady, I have dealt with the reasons that the applicant and the Helen Suzman Foundation do not want Mr. Chang to go to the USA. I think it's fair to put them this way. One, it is because they believe that when he is in Mozambique, he will not be prosecuted or he will be treated leniently. One. Two, I had my learned friend, Mr. Cohen, I think it was, and if it wasn't him, I apologize. It must be my learned friend for the Helen Suzman Foundation then, say that these people are fugitives from the law, and if he's taken to Mozambique, he will run away, he will leave the country. Well, my lady, on the evidence, on the facts that were before the minister, there was no suggestion or no facts put to the minister that Mr. Chang is a fugitive from the law, that he has run. In fact, on the contrary, the applicant says in his papers, he has freely moved in and out. So he has traveled out of Mozambique and he has traveled back, returned to Mozambique. So which contradicts the submission that if he's returned, at least at face value, my lady, would contradict the proposition that he is a fugitive from the law. But perhaps more importantly, my lady, this is the point when one has to have regard to the indictment itself. That in fact the indictment states that he would have to be, it is intended that he should be held in detention or custody for purposes of the trial. So we know, and this is what is put to the minister together with in the indictment that is part of the submissions that were before the minister, that, well, the intention of Mozambique is to keep him in custody while he runs trial. So, my lady, when we make the submission that, or when the minister states in his affidavit and we make the submission that, well, it's for the Mozambican authorities to decide how to deal with him once he's there. Well, we know from the indictment what they intend to do, but even if one accepted, for purposes of argument, that in fact it's no more than it's preferable that there should be a warrant so that when he lands in Mozambique, he is arrested. It is no more than a preference, but in fact, even if that were to happen, my lady, the Mozambican authorities, just as with the American authorities, could easily decide to release him on bail once he's on their soil. The duty of the minister is to have him delivered to the Mozambican authorities. That's what Section 11A requires of the minister. He delivers him there, and we know from the indictment that it is intended that he will be kept in detention for purposes of trial. So to the extent that the concern about the interest of justice is about whether he will remain in Mozambique to stand trial, my lady, I've addressed that issue and the obligations of the minister relating thereto. The second concern about the interest of justice, or that is raised as we understand it, my lady, is that, Americans have been affected by his conduct, or by the alleged conduct. The American financial system has been utilized or used in this alleged malfeasance. The answer, my lady, is to the extent that that is one of the reasons that are being posited as supporting the complaint that it's in the interest of justice that you should go to the United States. Well, equally, my lady, it is in the interest of Mozambicans, and my lady, it's in the submissions of Mozambique to the minister that it is in the interest of Mozambique that he should stand trial in Mozambique. And among the factors, and your ladyship will see that in the submissions, in the summary to the submissions, and we deal with it in our answering affidavit, my lady, that in fact, Mozambique says we have to be seen to be fighting corruption. We have an interest in being seen to be fighting corruption. We intend to do that. Our donors require of us to fight corruption, and having Mr. Chang back in Mozambique or stand trial in Mozambique would support our fight to show our determination and commitment to the global commitment to fight corruption. And that is what is before the minister. And as I said, my lady, that the exercise is not, well, which is preferable. It is whether in taking that into account, or having taken that into account, what the Mozambicans say about why it is, it is in the interest rather that he should come to Mozambique. The decision, there's nothing irrational about that, about the acceptance of those submissions. Now, if I may then go back, my lady, to deal with the issue of the warrant. Now, I think firstly, I must address my learned friend for the Helen Suzman Foundation when she says, the minister says in his affidavit, it does not matter that there is no warrant of arrest if there is no warrant of arrest. My lady, there is no such statement from the affidavit of the minister. He doesn't say that. My learned friend mischaracterizes what the minister says. The minister says, even if there is no warrant, and I dealt with the matter on the basis that there is a valid warrant. If you find that there was no valid warrant at the time that I made the decision, that error of mine to accept that there's a valid warrant, and it's an error of fact, my lady, to accept that there's a valid warrant of arrest, that error is not material to vitiate my decision. That's all that he says. And that's profoundly different from the statement that the minister says it doesn't matter that there's no warrant. He simply doesn't say that. And there is no basis. It's not factually correct for my learned friend to misrepresent the affidavit of the minister. It simply doesn't say that. Now, yes, my lady, as Mr. Cohen says, where the minister says there's a warrant, there was a warrant, he was referring to the international warrant. And Mr. Cohen correctly points out that, well, Chang Wan made findings or pronounced on the validity, on whether there is a warrant, in fact, for an effective or valid warrant for Mr. Chang's arrest, and found that in fact there isn't. My lady, the submission I make is, well, even if there is no warrant, your ladyship accepts that there is no warrant as the international, to the extent that the minister relied on the international warrant, and I must concede, your ladyship would fairly, if your ladyship accepts that there was no warrant or valid warrant before the minister at the time that he made his decision, that finding would be fairly made. However, on the back of that concession, my lady, I make the submission that that error, if you like, of law about the validity of the warrant that was before the minister is not material in the circumstances. And the reason we say it is not material, my lady, is that, as I have already mentioned, that the indictment itself states that it will be sought that Mr. Chang must be held in detention to stand trial. So that's and that was before the minister. But secondly, my lady, he is delivered in terms of Section 11A to the authorities of Mozambique. He doesn't walk in, and I think my learned friend from the Helen Suzman Foundation went so far as to say, well, he'll just walk into Mozambique from South Africa. My lady, I think this. I suspect the statement was made for effect, not for its correctness. And if it was made to to suggest or to submit that it's a fact. My learned friend has no basis to make that statement. Mr. Chang is in custody. Mr. Chang, and this is ventilated. In fact, I think the applicants if I'm not mistaken, in Part A, in that affidavit, they say, well, he's going to be surrendered any time now to Interpol. That's why we need an interdict so urgently, so extremely urgently. So his departure from here, and I think, my lady, it can be accepted as common cause. And that from he's in our custody, he gets delivered to Interpol. Section 11A says he must be delivered. The minister must ensure or order that he must be surrendered to a person authorized by the foreign state to receive him or her. In this case, a person authorized by Mozambique. So Mr. Chang doesn't just walk into Mozambique on his own. We don't release him at the border for him to decide what he wants to do when he gets there. My lady, that's a further reason why we say that even if you find, as I expect your ladyship will find, that, the minister was mistaken to accept that there is a warrant, because that warrant has already been pronounced upon, then these two reasons, in the light of these two facts, in fact, the factors that were before the minister, your ladyship must find that the error is not so material as to vitiate the decision of the minister. And then, my lady, the next criticism is the minister's failure to provide reasons for his decision. Now, my lady, perhaps let me start right at the beginning and address an issue. The memorandum, and the memorandum, my lady, the internal memorandum, your ladyship, I don't intend that we've been discussing it. Your ladyship will note that it's at 06205. Now, that memorandum, what it does is we state what the purpose of the memorandum is, and I will not bother your ladyship with what it says, but that is contained in our submissions. And it is prepared by a departmental official, and it recommends that Mr. Chang must be delivered to Mozambique. Now, that memorandum, my lady, was delivered as an annexure to the answering affidavit when it should have been part of the record. And we ask, I think the minister says in his answering affidavit that he will ask for condonation, that the affidavit the memorandum must be considered as part of the record. Now, my learned friend, Mr. Du Plessis, says we should have brought an application for condonation, set out fully the reasons why the memorandum was not included in the record when it was filed on the 30th, and we did not do that. And I suppose by that he's saying, well, there's no application for condonation. Well, my lady, firstly, I would submit that we cannot lose sight of the extremely urgent circumstances in which this application was brought. The parties were agreed that the matter deserves to be heard on an urgent basis, and with very seriously constrained or truncated timelines to file. Now, the applicant, and perhaps let me correct a factual inaccuracy. My learned friend says we had said we would deliver the record on the 27th of August, and we failed. And then we asked to deliver it on the 30th. Well, that's not factually correct, my lady. I don't believe, my lady, that much turns on it. But to the extent that these are matters of record, it is important that perhaps I should correct that. And if for no reason, then perhaps for the reason that Mr. Du Plessis repeats quite a few times that, well, the minister is led by senior counsel and a junior and a senior state attorney. So perhaps I must deal with this, my lady. The applicant in its Part A, notice of motion, demanded or chose that we must file the record by the 27th. So the matter would have been in court on a Tuesday. And so the application was set down for the Tuesday, and they wanted an interim interdict pending the determination of Part B. And among other things, the orders that they sought is that we must file the report on the 27th. My lady, the reason that in the end, Mulahi J granted an order that the record would be filed on the 30th was because of a concern that we wouldn't be able to meet the deadline of the 27th. That the applicant, as it's entitled to do, when it comes to, as any applicant is entitled to do when they approach the court on an urgent basis, to fix their timelines. They had done that. And we were in court, my lady, the matter was set down for a Tuesday. We were in court, we went back to court, I think on a Thursday, on the next day when we then discussed this order and ended up with an order, maybe Thursday or Friday. And I requested on behalf of the minister that we should be afforded until Monday to file the record. So we did. We filed on the 30th. It was still done on an extremely urgent basis. The intervening period was a weekend, my lady. And perhaps the minister should have been better prepared, as my learned friend, Mr. Du Plessis, and maybe that's, the other ministers, and Mr. Du Plessis himself work that way. When they've made a decision, they start collecting documents because they anticipate that they may have to be reviewed. But we know that as a matter of practice, and that can be taken note of, my lady, that records are supplemented all the time in matters for review purposes. And that in itself is not a matter that draws criticism unless there is evidence that this was deliberate, it was done in disregard of the rules, or some other maleficent reasons. Now, that cannot be the case here, my lady. The memorandum was disclosed, and we accept it should have been disclosed with a record on the 30th when it was filed. But it wasn't, and the minister says it was inadvertently left out. Now, I think one can fairly say on this platform that, the minister does not compile the record. The officials in the department, as happens with all review applications. So to the extent that some punishment must be meted out to somebody for not filing the complete record, it cannot be on the minister on the basis that he was responsible to file the record and he chose not to file the whole record. But my lady, the record, the memorandum is before your ladyship now. And given the nature of these proceedings, that is a review application, which is based on, in fact, the review of the decision is based on evaluating the information that was the decision of the minister against the information that was before the minister. So the memorandum is relevant for that reason, and should be taken into account. It follows that your ladyship it is in the interest of the proper prosecution or consideration of this matter that condonation should be granted. I think the impracticality that Mr. Du Plessis says should have happened, that we should have brought a full-scale application, that he should have been able to answer with affidavits, we wouldn't then be arguing this matter today, my lady. It's simply not appropriate for an urgent application. Now, so that deals with the condonation, and I would ask the ladyship to condone the filing of the supplementary of this document with their answering affidavit. The further criticism that is made is that the minister issued the reasons document. In fact, I think they say he was concealing. It might be the memorandum itself, my lady. The minister was concealing it, and it is when the applicant said, "Well, there's a reference to a memorandum in an email that the minister's game was up. He had to now disclose the memorandum." Well, my lady, if nothing else, in fact, that memorandum shows the inadvertence of, or that shows that this memorandum would have been omitted. In fact, let me not put it higher than would have been omitted inadvertently when the record was filed, because it would be nonsensical for whoever compiled the record, be it the minister or official, to disclose a memorandum, rather an email that makes reference to a memorandum, and not keep that out, and then withhold or conceal the memorandum deliberately when they have included in an email. It hasn't been suggested that, well, the email itself was disclosed by unintentionally. It has not been suggested that, my lady. So, my lady, indeed, perhaps we should have given an explanation more substantive than just saying it was inadvertently left out. But I submit, my lady, that we describe, or that's the explanation we give, does not warrant the exclusion of this memorandum, but also, more importantly, it does not support that there was an intention to conceal the memorandum for the reasons that I have stated. Now, the minister, and let me go back to speak to the reasons, my lady. The minister has provided the reasons, and perhaps a minor point that my learned friend, Mr. Du Plessis, makes more of it than I think is necessary, or I would propose is necessary, is the fact that the heading of the reasons for decision document is the citation, is this matter. Well, my lady, the date given in that written document, of course, these proceedings had started. And the minister doesn't say, "I've always had this document in my office." You know, he doesn't say that I've always had the document. So your ladyship can accept, because that's what it represents on the face of it, that this document was prepared after these proceedings were instituted. And you see that simply from the date, my lady. And we submit that in itself, nothing turns on that, because it's not, in fact, if anything, it shows that the minister intended to put this before your ladyship. Now, my learned friend says, or my learned friends say, that the memorandum contains reasons why Mr. Chang should be extradited to the USA. And that those reasons are the reasons for the decision of the minister. And they do so by saying that he accepted the reasons, or those are his reasons, and you see that from the signature in the last page of that memorandum. Now, my lady, of course, we should have submitted an affidavit if we should have submitted an affidavit that explains the signature in the affidavit, in that memorandum, the minister's signature in that memorandum. There is no such affidavit before you presently. And what it is, my lady, and I put it no higher than to say, and I accept, my lady, that it is not evidence before your ladyship. In fact, perhaps let me make a different point first. That if your ladyship has regard to that memorandum, as my learned friends have taken your ladyship through the signature pages to indicate who signed and. Now, and Mr. Jeffries, Deputy Minister, also signed. My learned friend, I think perhaps he was musing loudly that, well, what is the position of the Deputy Minister on this matter now that the Minister has decided to surrender Mr. Chang to Mozambique? Well, it's not the decision of the Deputy Minister that's at issue here. It's a decision of the Minister. Whatever Mr. Jeffries may think about what the Minister ultimately did, which is to order that Mr. Chang must be surrendered to Mozambique, whatever he thinks is irrelevant for our present purposes. What is being evaluated is the decision of the Minister and the reasons for his decision. Now, my lady, it's not disputed that given when the written reasons when the written reasons are submitted or given to the parties, given the date of that, your ladyship must consider that document critically. We don't make quarrel with that. That is what the law is. Your ladyship is required to look at it critically. The submission that we make, my lady, is that your ladyship must have regard to, and my lady, accept the concerns about, well, if the Minister says these were my reasons, they were in my head. I just did not put them down until some date after, and that date is the 31st of August, according to the reasons document. The Minister says, well, those are my reasons. I accept, my lady, that your ladyship must consider that critically. But accepting that, my lady, my submission is, well, that in itself is not by and of itself a reason to simply jettison these reasons. That's not what the authorities are saying. The authorities are saying
contemporaneous, Ms. Beloy. Should they not be contemporaneous?
My lady, I think if they were contemporaneous, we wouldn't have this controversy that we have now, and they should be. Then we don't have a problem, because there's then no debate about whether those were the reasons that informed the Minister's decision at the time. So the answer is yes, my lady. But in this case, where they were not contemporaneous, and it's apparent from the document itself, your ladyship is being asked to consider how much stock to put, and I use the informal word stock, my lady, to put to the Minister's assertion that, well, these were my reasons, they were in my head at the time. It's really that. It is, well, we are asking your ladyship to decide how much faith do you put in that, and in making that decision, my lady, I submit that your ladyship would have regard, must have or should have regard to whatever the defects with the fact that these reasons were not recorded contemporaneously that the Minister is giving. Are they anyway, when you look at the record, and my learned friend, I thought Mr. Duplessis was making the point that, well, the reasons must appear from the record, and my submission, my lady, is if your ladyship has regard to the record, and we've made the point in I think in the affidavit, but also in the heads of argument, that, well, the factors listed by the Minister as factors that he took into account in deciding that Mr. Chang should be surrendered to Mozambique are factors that are not extraneous to the record. It's exactly, at least as I understand Mr. Duplessis, it's exactly that point that he's making, that when you look at the record, are these reasons reflective of what is said in the record? And my lady, I have dealt with the issues of immunity and temporal primacy and all those other grounds for review. My lady, I will not make any further submissions, safe to say we do deal with this in our written submissions. My lady, I believe that I have addressed the grounds for review, and I don't believe that I have left any one of them out. But the submission ultimately, my lady, about these grounds for review that I made is that perhaps except for the debate about the status of these reasons or the reasons document, and to a lesser extent, the debate about the validity or the absence of a warrant of arrest at the time of the minister's decision, the other grounds for review absolutely have no merit whatsoever. These two, they do raise a debate indeed, my lady, and I have made my submissions in that regard. If your ladyship would bear with me. My lady, then, having done that, the next issue that I will deal with is the appropriate remedy. Mr. Duplessis seeks that your ladyship should substitute her decision for the decision of the minister, and order that Mr. Chang should be extradited to the USA. We have raised a number of reasons why we say such an order is not appropriate in the circumstances.
But is the minister's decision, if the matter were to be sent back to him, is his decision not entrenched now? It's on paper.
My lady, I don't. Well, the minister may well have. He may. Perhaps let me say this, my lady. The two, at best, my lady, the two reasons that would, at least as we understand it, as we conceive it, that would possibly result in the decision being set aside is the absence of a valid warrant and the reasons, the absence of contemporaneous reasons. Those would be the two issues. But when your ladyship says, isn't his position entrenched? My lady, yes, if his position is entrenched, indeed, perhaps that's a reason. That's one of the factors that the court would take into account in deciding to substitute. But if your ladyship has regard to the reasons that he provides, why Mr. Chang should be extradited to Mozambique, your ladyship would have to say that, well, there's absolutely no validity in any of the factors that he took into account. Your ladyship would first have to make that determination and then say there's no validity to those factors, and because he proceeded nonetheless. So, and effectively, your ladyship would say he's not capable of being neutral in the matter and considering this matter with a fresh mind. But the factors that he has taken into account, they are objectively verifiable factors, lady. We've discussed the various opinions. We have discussed the submissions, that on the submissions that were made before him, that there is an indictment, there is an intention to hold Mr. Chang in custody while he undergoes trial. Those are objectively verifiable issues. And if this were an appeal, my lady, I would say, well, those remain true if there's no change of circumstance. If you accept that those are correct facts, it shouldn't change anything. In fact, my lady, your ladyship would have to, if your ladyship were to perhaps it's correct to make the submission, my lady, that if your ladyship were to substitute or to be minded to go down the path of substituting, your ladyship would have to deal with these objectively verifiable facts that but for the absence of contemporaneous reasons would be factors that must be taken into account. So the status of Mr. Chang's immunity, your ladyship would have to make a determination on that. And your ladyship has to be satisfied that before your ladyship has sufficient information about the status of his immunity, because that is one of the factors that must be taken into account when a decision is made afresh, whether by the minister if the matter is remitted to him, or by your ladyship if your ladyship decides to substitute. Your ladyship would have to deal with what my learned friends or what the applicant says, which is he will flee Mozambique if he's returned to Mozambique, or there will be no effective prosecution. Your ladyship, when invited to consider substitution, in fact, is being invited to make determinations on those issues. Because unless your ladyship is satisfied that Mozambique is disqualified from, in fact, let me say it differently, my lady, that it's not an automatic decision of substitution that, well, I find that what the minister did doesn't pass the test of rationality. Your ladyship would have to say, to deal with the various grounds for review. And we say that as matters stand, there's only really two grounds of possible, which possibly lend to an outcome where your ladyship may well then have to deal with the question of remedy, of substitution, in fact. And your ladyship would then have to say, to consider whether is there a valid warrant for his arrest. Your ladyship has to look at that. Your ladyship, as I say, has to satisfy yourself that Mozambique submissions were made in bad faith, because that's what it would entail. You would have to satisfy that the criticism that it was made in bad faith is correct. So there is, in fact,
this, Mercy. Okay.
So
I am going to mute.
Thanks.
So your ladyship is being.
Sorry, Ms. Boloi, you muted.
Yes, I see, my lady, that Sophia, every time she mutes others, I also get muted. I do apologize for that.
There's someone else on the platform that hasn't muted their videograph. Who is CN? Please leave the platform.
So
Right.
My lady, the submission I'm making about substitution is, it's really not a simple case of, well, the outcome is obvious, as my learned friends say. Your ladyship has to satisfy yourself about the various criticisms that they do have merit. Your ladyship first has to say that. And then, and that includes the issue of immunity, the issue of the warrant, bad faith of Mozambique. And we simply say, well, your ladyship is not in a position to make a determination on those issues. In fact, it's a big ask of your ladyship. But considering the reasons that the minister has offered for why he's decided to surrender Mr. Chang to Mozambique, I submit, my lady, that, well, it's not the kind of reasons where you would say, well, he's entrenched in those reasons. Those are objectively verifiable. They're either correct or not, the facts on which he has relied, and that he would uphold them if they are correct facts. Is not in itself a reason why your ladyship should substitute as proposed by my learned friend. My lady, the further submissions, we stand by the further submissions that we have made regarding this remedy. The applicants, perhaps one that also requires a direct answer is the applicant states that the minister, or alleges that the minister is biased. My lady, it doesn't follow. Even if your ladyship found that his decision is cannot be sustained, and is liable to be set aside, it doesn't follow from that his decision is that he is therefore biased. It doesn't follow from that. One would have to look at the facts. What are the facts that point to the minister's bias? Because bias is not a neutral appellation. What it is you favor the one side irrespective of the merits that are before you. And my lady, I submit that in this case, the reasons that the minister has proffered, they do not in any way exhibit a bias, and nothing in what the applicants have put before your ladyship speaks to any such bias. And we submit, my lady, that your ladyship, for those reasons that we set out in our heads of argument and as further supported in these oral submissions, should not agree to substitute. And in fact, my lady, this was the other context in which we have spoken about the court deferring to the statutorily authorized person, and we say in the absence of those circumstances, you should defer to the minister. And your ladyship can do so with the necessary safeguards if indeed there is real concern about how the minister will make the decision. In fact, a further reason that the applicants have raised, that the applicant raises, why there should be substitution, is that Mr. Chang has been in custody for too long now. It's common cause that he's been there for more than 2 years, and it's quicker. That's what the applicants say. It would be quicker that the court simply substitutes and send him to go and stand trial. Well, my lady, the submission we make there is, well, your ladyship does not have information before you which tells you that if he goes to the United States, he will not remain in custody for any extended period of time. What we do know from the submissions from Mozambique is that trial is presently underway. So we know that at least, but we do not know anything about the United States position. Yes, they were first in line with the indictment, with preparation for trial. They pipped Mozambique to it, and they were much readier. It is since Chang won, so much time has passed, my lady. The United States have had the opportunity to place facts before you about what is the state of affairs now if Mr. Chang were to be extradited to Mozambique. That information is simply not before your ladyship. And I make the point only, my lady, to say, in answer to my learned friend Mr. Du Plessis' submission and the applicant's contention that he's been in custody for too long, it's only fair that he should be released. Well, he's not being released to be free and go home. He will be released whether to USA or to Mozambique to be kept in custody. And it may well be that he continues to wait for his day in court. We simply do not have that evidence before you. And finally, my lady, with regard to costs, my learned friend, or the applicant, let me say, seeks a punitive cost order, including that the minister must personally pay 15% of the applicant's costs. Now, my lady, the reason we have taken the position that we've taken is because the applicant does this for the first time in the replying affidavit. In the applicant's founding affidavit, it doesn't set out why it is appropriate that they must get a punitive cost order and the minister must pay costs personally, which we would have met and answered and said to your ladyship why. that such an order is inappropriate. What they do is they kick the can down the road. We submit that if there is no reason that the issue of cost cannot be dealt with now, my learned friend has simply not made out the case for the punitive cost order. In fact, part of the criticism, my lady, we have dealt with the issue of the record, and I have said, my lady, that, well, records are supplemented every day, and that in itself does not entitle you to a punitive cost order. At least there's no authority that I'm aware of that because you didn't file a record once off, that warrants a punitive cost order. One has to also be in addition, one has to be mindful of the urgent circumstances in which this application was brought. Two, the minister is criticized for entering the merits. Now, my lady, there's no law that says an administrator, and we'll use administrator for present purposes, that an administrator must not participate when their decision is sought to be reviewed. There isn't such a law. But this case, my lady, if one looks at how my learned friend, how the applicant, maybe in fairness to my learned friend, let me distinguish between him and the applicant and the deponent, in fact, the deponent to the affidavit, that the allegations that we've used the word intemperate language and tone of the papers, but more than that, my lady, in their papers, they accuse the minister of dishonesty, of incompetence, of bias. Now that's a reflection on the person of the minister and the manner and his conduct, malfeasant conduct, in arriving at the decision that he did, in making the decision that Mr. Chang should be extradited to Mozambique. Now, my lady, if a case ever called for a decision maker to file papers and say an answer, it is this, the minister could never be expected, and fairness and justice, it would be grossly inequitable to say, well, the minister should have let the dishonesty allegation go and trust that the court will troll through the record and say there's no evidence that he was dishonest. There's no basis in law for that. Similarly, to suggest that the minister should have said, well, they say I'm incompetent. It doesn't matter whether they're right or wrong. It doesn't matter what the world out there thinks about me as a minister being accused of incompetence. I cannot enter this, because if I enter this, if I try and answer and defend my decision to show that I'm not incompetent, to show that I was not being dishonest, if I do any of that, I run the risk that I will be marked with a personal cost order. That could never be justice, my lady. That could never be fair. So this is a case, in fact, in the manner in which it has been litigated, and your ladyship need only troll through the founding affidavit, the supplementary affidavit, and the replying affidavit to see the manner in which the deponent to the applicant's affidavit has chosen to litigate this matter. My learned friend, my learned junior, has used the expression that the ad hominem attacks or comments on the minister are completely unwarranted. My lady, in the face of that, it couldn't be fairly said that the minister should not have taken the position to answer and explain himself. And explain how he came to this decision and why he came to this decision. But also importantly, my lady, he does give a full explanation of how he came to his decision. So, my lady, this is not a case for a punitive cost order. However, my lady, if your ladyship is of the view that, or comes to the view that that in fact the punitive order sought by the applicant may well warrant consideration by the court, proper consideration. What I would propose, my lady, is that it is the fair order to make in the circumstances would be to then direct that the parties must file the papers, and being mindful. I make this, my lady, this proposal, being mindful that in fact it is really in the replying affidavit that the applicant seeks to make a case for a punitive cost order. We couldn't have answered that because it wasn't set out in the way that it's set out in the replying affidavit. So we couldn't have dealt with it. So if your ladyship, firstly, the first submission I make about it, my lady, is this is not a case that warrants a punitive cost order, and simply because the minister has participated, chose to participate, and simply because the record was not delivered on the 30th, rather on the 30th in full, and other documents came in after that. That in itself doesn't warrant such a finding. And maybe lastly, my lady, because your ladyship was not involved with Part A, part of what my learned friend relies upon for this punitive cost order sort is that when before it instituted these proceedings, it sought an undertaking from the minister that Mr. Chang would not be deported, or rather would not be surrendered to Mozambique. It sought the undertaking, I think on a Thursday, thereabouts, that he would not be sent out until Monday. He would not be handed over. It's common cause that the minister refused. There was no application at the time, my lady. When this undertaking was sought, there was absolutely no obligation in law for the minister to give such an undertaking. However, once the application was launched, and in fact, rightly, my lady, once Mozambique indicated that it is prepared to await the outcome of this hearing that we have now, once that was done, the minister fairly said, in the light of the position adopted by Mozambique, I have no reason to insist that Mr. Chang should be surrendered. We are in this litigation. Mozambique is willing to, or is prepared to wait until this hearing has been exhausted. In the face of that, I have no interest in having him surrendered to Mozambique. My lady, that's reasonable.
Yes, I think the order of my brother, Judge Mashaleli, says to the hearing of today, is that undertaking, can I accept that the undertaking is given until I hand down my judgment?
That would be so, my lady. I think the spirit behind that order was that we must afford this court to determine this matter, and that would extend to your ladyship handing down judgment. So what it would entail, my lady, is that your ladyship would, at the end of today, extend the order to a later period. Yes. Right. So, my lady, those are my submissions on the issue of cost. So the one is the punitive cost order as sought is not warranted, but should your ladyship consider that it does require consideration by the court, I submit that the appropriate manner of dealing with it is for your ladyship to afford the parties, which anyway Mr. Du Plessis was prepared to do, is to afford the minister the opportunity to deal fully with why such an order is not appropriate in the circumstances.
Obviously.
Those are my submissions, my lady.
Right, thank you. Thank you very much, Ms. Beloy. It's been a long session.
It's been indeed. Your ladyship.
It's 10 to 3 now. I think we should just take a 10-minute adjournment and start again at 3 o'clock. Mr. Makari, is that all right for you?
That will be in order, my lady.
All right. So we'll just mute ourselves until 3 o'clock. Thank you. Right, Mr. Makari. Mr. Makari there.
Yes, I'm here, my lady.
Right.
Thank you very much, my lady. I'm not going to be unduly long. I just have to cut to the chase.
Yes.
Given the extent of our participation as the Republic of Mozambique, I'm going to address the following topics in my submissions. That would be the issue of immunity, whether Chang enjoys immunity or not from prosecution. And that issue you see as I make my submissions, my lady, that it is both a factual and legal issue.
Right.
And the second one is whether there is a warrant of arrest which can be effected upon Mr. Chang touching on Mozambican soil. Again, then that is a legal issue. Well, it's a factual, which will be the existence of it, and then the legal issue arising from the existence or absence thereof. And the third one will be the indictment, whether there is an indictment, and then also it turns on the factual existence or non-existence of it, and then the legal issues that arise from it. And the fourth one, actually, I'll deal with what will be an appropriate remedy in the circumstances where the court rejects all our submissions, and the court is inclined to grant the order. So that is the sequence in which then I will make my submissions. But before I start doing so, let us set the parameters so that we know in terms of which the nature of the proceedings. This is motion proceedings sui generis. It is motion proceedings sui generis in a sense that it is motion proceedings of Rule 6 adapted to the provisions of Rule 53. I say adapted to the provisions of Rule 53 because the Rule 53 permits that which Rule 6 does not permit. And when I say that Rule 53 permits that which Rule 6 does not permit, is that under Rule 6, the applicant must make out his or her case in the founding papers. And the respondents will file their answer, and there will be a reply, and that constitutes the pleadings. So that is evidence before court, which the court must consider, and the court can't take anything extraneous to it. But then the application under Rule 53, it is still motion proceedings, but it permits the applicant a second bite of the cherry. So it goes against the rule that you must make out a case once and for all in your founding papers. It gives you an opportunity to call the decision maker to provide you with a record. The decision maker must comply with that and must provide you with a record. Once the decision maker has provided you with a record, you have a second bite of an opportunity to file a supplementary founding affidavit. So that's why that supplementary affidavit is one that does not require leave of the court, whereas under Rule 6, if you were to file a supplementary affidavit, you can't do so without leave of the court. So you'll then be permitted without leave of the court to file a supplementary founding affidavit based on what you have found in the record, which was dispatched by the decision maker. And then from there, the respondents will have an opportunity to file their answering papers, and then from there it will be the responding, then the replying papers. Then the reason why I start this way, it is to deal with allegations or averments which your ladyship will find or has seen made in the founding affidavit and the supplementary founding affidavit, and how they've been answered to by Mozambique. your leadership, of course, under Rule 53 review, will have to consider the record, but your leadership does not consider the record in a vacuum. Considers the record in relation to the allegations that are made by the parties under oath, to the extent that they don't detract from the objective facts. So the record represents objective facts. But where allegations which ex facie are not to be found in the record and they are made by the applicant, those allegations must be answered to by the respondent, and the respondent must answer them sufficiently. If they're not answered, then the court is inclined to accept them as admitted facts. But where then the allegations have been answered sufficiently by the respondent, and that's where now then the pluscon events test come in, that the court will have to resolve factual disputes which are not ex facie the record in accordance with the pluscon events test. So that's the parameters then upon which then we're going to then persuade your leadership to look at the amendments which are made by the applicant as against the responses that have been made by Mozambique under oath, as long as then they can be answered by the record itself. Then the starting point now, because we're dealing with a review here, is the statutory, then the statute that comes into play, we'll call it an enabling legislation. Then the type of the decision that the minister is required to make is one that is regulated by statute. So before the minister can do anything, he must satisfy himself as to whether there is an empowering legislation or provision which entitles him to make the decision. And that's really what we call legality. It is a legality because of the what the Constitutional Court has said in Newclicks and in Fetshaw, that a functionary can do nothing other than that which is provided for by law. Anything outside the empowering law is ultra-virus and invalid. And if the minister is not authorized by any empowering provision to make the decision, he simply can't make that decision. And that's the end of the matter. So that's why in the matter.
Sorry, you muted, Mr. Makari. Somehow you've muted yourself.
Oh, I think that you did automatically somehow. Okay, thank you very much, Malida. Let me just repeat. I was just saying that in this, in the context of a decision that is at play here, which is to extradite a person on South African soil in order to stand trial in a foreign state, the minister must satisfy himself that there is an empowering provision which authorizes him to do so. And if he can't find one, he can't make the decision. But if he finds one, he must look at it and interpret it in such a way that he acts within that power. Hence, the starting point is going to be, what is the law which authorizes me to do so? And in the South African context, everything revolves around the Constitution. So the Constitution always is the starting point because in interpretation of any legislation and in application and enforcement of anything in the country by both the executive, administrators, it must be authorized by the Constitution because of the provisions of Section 1, subsection C of the Constitution, which says that the supremacy of the Constitution and the rule of law. And that supremacy of the Constitution and the rule of law must find expression from the legislation that Parliament will enact in order to give powers to ministers or the executive to do or not to do certain things. And in this case, then it brings us to the Extradition Act, and that's where the minister must look at. So we first have to look at the applicable provisions of the Extradition Act in order to find any power that the minister can exercise. And Maledi, for present purposes, we'll confine ourselves only to section 9, 10, and 11, because those are the relevant sections. In fact, you'll see as well, Maleri, that in the judgment that we have cited in our heads of argument of the Supreme Court of Appeal, which when I checked, it seemed to me that either it is not yet reported, or at the time when I printed it was not reported, the judgment of Riatile Thabo Mutshebelele versus Director of Public Prosecutions, Gauteng Local Division, Johannesburg, and others. So it's a judgment of the Supreme Court of Appeal delivered on 31 May 2019. It was also dealing with the provisions of section 9, 10, and 11, although it was dealing with it in the context of the review of the decision by the magistrate to release somebody whom Lesotho has made an extradition request through note verbal, and the magistrate decided to release that person. So the court had to interpret the provisions of section 9, 10, and 11, and those are the provisions that I'd like to look at in the Act itself. So in terms of the sequence, you'll see, my lady, that in terms of section 9 of the Extradition Act, it tells us about persons who are detained under warrant to be brought before magistrate for holding of an inquiry. So this type of detention is one that we are not dealing with in the current matter, because this is a detention on South African soil. It is a detention of somebody who is found on South African soil, and a request has been made by a requesting state that the person must be handed over to that state in order to stand a trial. So it will tell us about how the extradition proceedings start. So they will start with the arrest of a person because of there is a warrant that has been issued that should he touches on South African soil or should be found on South African soil, then he must be arrested, but he must not be arrested for the sake of him or her being kept in jail indefinitely, but he must be arrested so that an inquiry must be held before a magistrate. And the magistrate performs an important function because he decides on the facts that are placed before him whether the person should remain in detention, and then secondly, which is most importantly, to submit a report to the minister in order for the minister to make a decision. And then I want to say that a political decision. So it is for the minister to make a political decision on whether then the person is extradited. And the minister, of course, is given certain powers that, notwithstanding what the magistrate has said, that the person is extraditable, but the minister then may still decide not to extradite the person, but he can't just do it willy-nilly. He must still be informed by the provisions underpinning the discretion that is granted to him. So what do we then have after that inquiry, which is not in dispute in this proceedings? Your Ladyship can accept that there was a Section 9 inquiry which took place, actually 2 Section 9 inquiries which have taken place. Nobody has taken issue with them. Well, at first, FMO did take issue with them in Chang 1, but the court then declined then to grant that order to set aside the proceedings that were before the magistrate. But what the court did in Chang 1 was to acknowledge that those proceedings have taken place under Section 9 and did not see anything wrong with them. And the outcome of those proceedings before the magistrate was that Chang is extraditable to both Mozambique and the US. And he submitted the report to the minister and for the minister to make a decision. Of course, as I have said, the minister is not bound by what the magistrate has said. The minister must still consider the matter, and he must apply his mind and apply the law insofar as it pertains to him. Because in Mutshebelele, which I've just referred to your Ladyship to, the Supreme Court of Appeal has said that both these two functionaries, which is the magistrate and the minister, play clearly distinct roles. The magistrate is to conduct an inquiry and make his own findings. And the Supreme Court of Appeal referred to the findings of the magistrate as preparatory findings. And then on the other hand, the minister will make a political decision. In fact, then I'll refer to paragraph 14 of Muchebelele judgment at page 7 of the judgment, where then the court says, Section 10 sets out the issues the magistrate should consider at such an inquiry and the competent orders the magistrate is entitled to make. And then from there, it quotes that section. And then from there, it refers us to the powers of the minister in section 11 at paragraph 15. Then at paragraph 16, it says the following. On a simple reading of sections 10 and 11, the magistrate and the minister both play a role, but with carefully delineated duties and responsibilities. The magistrate's duties are confined to making certain preparatory findings, while the minister makes substantive and political decisions as regards the extradition or otherwise of a person sought by the requesting state. And the reason why I emphasize this, my lady, is that the extradition of a person involves the interface between two sovereign states. They interact with one another at diplomatic level. That's why even requests must follow diplomatic channels. It must be submitted to the consular, and it must follow those protocols until it reaches the relevant minister. And the decision that is taken is a political decision. Of course, then it will still be subject to judicial review under Section 1C of the Constitution, as I've pointed out, that ultimately everything must revolve around the Constitution and the supremacy of the Constitution and the rule of law. But that does not detract from the fact that the minister makes a political decision. It is not an administrative decision. But then what then happens is that when the minister makes a decision based on the report submitted to him under Section 11, then the minister will make a decision. And let's look at what Section 11 says. It says the minister may order any person committed to prison under Section 10 to be surrendered to any person authorized by the foreign state to receive him or her, or order that a person shall not be surrendered where criminal proceedings against such person are pending in the Republic until such proceedings are concluded, and where such proceedings result in a sentence of a term of imprisonment until such sentence has been served. We know in the current matter, my lady, that Mr. Chang is not facing any criminal proceedings in South Africa, so he's not then hit by this provision. So what is available to the minister insofar as consideration of a request made by the requesting state about the surrender of Chang is whether then Chang can be surrendered within the prism of the empowering provision. So all what was available to the minister was the power conferred on him by Section 11, that on the report submitted by the magistrate and taking into account that the magistrate has ordered the continued detention of this person pending the decision of the minister must make a decision to surrender that person or not to surrender that person. Of course, he has to give reasons. Then if he surrenders, he has to give reasons if he does not surrender. So in the context of the current application, which your ladyship has the benefit of Chang 1 judgment, because then this matter is not coming before your ladyship for the first time. It has already been ventilated before the full court in Chang 1. So your ladyship will look at what is it that was debated and decided upon in Chang 1, and what is it that ought to have been done by the minister upon the remittal of the matter to the minister in Chang 1. Whilst, my lady, various grounds of review were raised by the minister, the current minister at that time, when he filed a counter application to set aside the decision of his predecessor, then the court upheld one ground of review, and that was one relating to immunity. And correctly so, because once, and as my sister, my colleague, Ms. Valoy has pointed out, once the court found that Chang enjoyed immunity, then it was the end of the matter, because then that is because that's a prohibition to prosecution, whereas the purpose of extradition must always be for the person to face a prosecution. So the other grounds were not dealt with. The issue of whether there was a valid warrant of arrest. For instance, you'll see when I deal with the warrant of arrest, that the international warrant of arrest that was actually issued in January 2019. But then no findings were made about that warrant at the time, because the court had found that Mr. Chang enjoys immunity from prosecution. But then what is quite important, and it was also debated, but not taken much then further in the judgment than in Chang 1, is that the Extradition Act, and you'll see that this is an old act. I mean, it's a 1962 act. So it's a very old act. Obviously, one has to try his best or her best then to interpret it within the Constitution. It never contemplated that one day a Constitution like this will come into being and govern the citizens and other people who are in the country. But anyway, what it does not tell us is what must the minister do when faced with two extradition requests. So that it doesn't tell us. But at least, my lady, the member states of SADC did acknowledge that there may be instances where concurrent requests may be made, and in their protocol on extradition, they inserted a provision which regulates what must happen when there are two requests, then extradition request. And the leadership will find that they've dealt with it in Article 11 of the protocol. And our submission, and I did not hear any countervailing submission, is that South Africa is a signatory to the protocol, a SADC protocol, and Mozambique is. And we say that as regional bodies, and they've signed and are signatory to this, this must be interpreted in a context of South Africa's obligation to international law and South Africa's international obligations. The South Africa, when it is signatory to international treaties, international agreements, it must comply with them. And that actually will be in accordance with Section 1C of the Constitution, because when it upholds its obligations, international obligations, it actually affirms the rule of law. So we say that the SADC protocol is binding on South Africa and Mozambique, and it has a force of law in the sense that the court is entitled to interpret it in the context of Section 39 of the Constitution when it takes into account international law in interpreting other legal instruments. And let's look at what Article 11 says. It says concurrent requests. 1, where requests are received from two or more states for the extradition of the same person, either for the same offense or for different offenses, the requested state shall determine to which of those states the person is to be extradited and shall notify those states of its decision. So paragraph sub 1 of Article 11 is very important in a sense that it informs the member states of SADC, those which are signatory to this protocol, that should you be faced with concurrent requests, and in this case, we know that South Africa, for the first time, actually in Chang 1, then this was actually then, raised with amusement, that in fact is the first time that South Africa then received concurrent requests. But it ultimately happened in real life. So here it was only in Article 11, but it happened in real life, and the minister had to deal with it. But Article 11 of the protocol then becomes an enabling provision to enable the minister to process both requests. So the minister must make a determination as to which of the two states he is sending this person to. So that he must do. It is his obligation. He can't then sit back and say that I've got 2 requests and therefore can't do anything. So that he must do. And as to which state he decides to do so, it is his decision and it must be his decision alone. But that decision he must always bear in mind. It may be subject to judicial scrutiny. So it must withstand judicial scrutiny, given the fact that any decision by a functionary, whether it is executive, political, or administrative, must comply with the rule of law. But the other obligation that he has under sub 1, upon him making the decision, he must inform the requesting states that this is the decision that I have made. So there is no contention, my lady, that the minister has actually done that, in a sense that he made the decision and informed then the requesting states. And the US is one of the requesting states. And we know that the US is not a party to these proceedings. It has elected not to take part in these proceedings. But we know that Mozambique is taking part in these proceedings, and because it has some direct and material interest in the outcome of the proceedings, but most importantly because the decision is in its favor and it wants to make sure that it proceeds without any delay to prosecute Mr. Chang. But let's look at sub 2, what it says. In determining to which state a person is to be extradited, the requested state, in this case the requested state is South Africa, shall have regard to all the relevant circumstances, and in particular to. So we can see that these circumstances that are enumerated from paragraph small letter A to paragraph small letter H are not exhaustive. But the operating weight here is all relevant circumstances. But in particular, and then the minister is being guided, is A, if the request relate to different offenses, the relative seriousness of those offenses, the leadership can accept as a matter of fact that there is no contention by any party in these proceedings that the offenses that are said to have been committed by Mr. Chang are serious. They involve then, fraud, then bribery, international, international offenses of money laundering and so on. So none of the parties is suggesting that the offenses are trivial. So that one we can tick it. Then B, the time and place of commission of each offense. We know that we're facing two requesting states here, and for obvious reasons, that these crimes or offenses that are alleged to have been committed by Chang, they are not border bound. They transcend country frontiers. They do so because of the nature of technology now, that corruption and money laundering can no longer be confined to one state because of the easy way by which people can transfer and transact. So here, the offenses clearly have been committed both in the United States of America and in Mozambique. So the money, there's the money that comes from the investors from Saraf, then from the United States of America, but the money was earmarked then for maritime projects in Mozambique in order to ensure that the economy of Mozambique is able to resuscitate and to assist then the people of Mozambique in general. And the money, of course, then was used not in the United States of America. It was used in Mozambique, then where they bought properties and do all sorts of things. So it is a cross-border offense of which no party here suggests that America does not have an interest in this matter. Of course, it does have an interest in the matter, but what can be said is that both America and Mozambique have an interest in this matter because then they are all have been affected, or both of them have been affected. So B, we can tick. Then C, the respective dates of the request. We know that America then made the request first, and after a few days, then it was Mozambique. But what the leadership will take into account, which is not contested, it is the lengthy historical facts that Mozambique has set out leading to the American request that the investigation started by Mozambique in 2015. Mozambique sought mutual assistance from the United States of America and other European countries. And America then was cooperating in order to assist Mozambique. But then later on, it was the same America then which made its own request, so that it made the request first. But those facts are the facts that also one takes into account. But then D, it says, and so the C we tick because we know that it is America that made the request first. Then D, then it says the nationality of the person to be extradited. He's Mozambican. So that is also important. And I still will want to hear from the applicant why, and I'm saying here, my lady, absent immunity, why it will be in the interest of justice to prosecute Chang, who is a Mozambican national in the United States of America, when he's sitting in South Africa, 500 kilometers away from Maputo. It is another important consideration. That is why they've put it here, the nationality. So it will be why it is in the interest of justice, a South African national who has committed an offense, which also then impact on South Africa and upon which South Africa has jurisdiction, must be tried in another country. The only disqualifying factor must be that South Africa is not going to prosecute that person. That can be the only reason. Other than that, one will see no justification whatsoever, whether in law or logic, than to take somebody, thousands and thousands of kilometers away when it can be tried just next door. Then E, it says, the ordinary place of residence of the person to be extradited is Mozambique again. So those are the factors that must be taken into account when a decision is made. And F, whether the requests were made pursuant to this protocol. And it is common cause, my lady, that the request of Mozambique was made in terms of the SADC protocol. And the US request was made in terms of the treaty that exists between South Africa and the US. G. Then G then says the interest of the respective states. So these states must have an interest. It seems to be not in dispute that both Mozambique and the US have an interest. So those interests must be taken into account. But the interest of this state is not going to be taken in isolation from the other factors, because you have to take into account all other factors. I will say, by analogy, how then our courts have taught us how to consider an indulgence or an application for condonation, that take all the factors into account and none of them are decisive over the other. So you must take everything into account cumulatively. And an H, the nationality of the victim. And we know here that the victim, and this is also emphasized by the US, then the US is not much concerned even itself with the fact that its investors have lost money, but it is concerned with the fact that money was made available to the people of Mozambique so that it can help the people of Mozambique, and that money was siphoned by politicians. And that is actually then what that is what the US also has an interest in. So if you talk of the victims of this hidden debt scandal, and those who were hit most by this scandal, it's actually the people of Mozambique. And the leadership will be alive to how the Constitutional Court has interpreted, when interpreting the Bill of Rights, that it always focuses on the vulnerable, and that the state's obligation to make sure that the vulnerable are protected. So even in this case, when you talk of the real victims, these are the people of Mozambique who have been really given a raw deal by these people who were heartless and siphoned $2 billion in money that was earmarked then to assist a country such as Mozambique, which desperately need that type of funding. So these factors are very important, and they must be taken into account by the decision maker when deciding where to surrender the person to. So, Malady, that now then takes me to what my learned friend, Ms. Valoy, said when she crystallized the case, and I agree with her completely, that whilst there are 5 grounds of review which are pointed out to your leadership in the founding in the affidavit, and I think further 3 grounds in the supplementary founding affidavit. But the crux of the matter revolves around 3 factors: immunity, warrant of arrest, indictment. But immunity looms large in the sense that in the absence of immunity, then I'll submit that there will be no justification why Chang can be surrendered to Mozambique, unless if there are facts that have been placed before your leadership to show that Mozambique is calling a bluff when it says that it's going to prosecute Chang, and in fact it has no intention to do so. But before the leadership can make that determination, then there is an important question that will still have to be asked. Why will Mozambique go to such length, investigating from 2015 when it had no pressure to do so, go overseas, get mutual assistance from Europe and the United States of America, including United Arab Emirates, and spend millions of rands to get Mr. Chang to be prosecuted when it has no intention to do so? It can only then happen really then, and not in the real world. So those are the questions that one will have to ask. But if Mozambique just came out of nowhere when America asked for the extradition of Chang, then there is something to talk about. That you had all this opportunity then to investigate this man, you did absolutely nothing. Then one will understand. So we say that immunity is central. And Chang one, of course, said, look, you can't extradite somebody to a country where he enjoys immunity. And we accept that that is so. But then when the minister, and I'm talking about the current minister now, because the previous minister, Mr. Masuta, made his own decision, and that decision was set aside by his successor, and then the court then, agreed with the successor and set aside that decision. But then what the court did was to say that you, minister, we are now directing you to look at the 2 requests. That's why then the order says 2 decisions that you made. That is the decision to extradite. 2 decisions that Masuta made: the decision to extradite to Mozambique and the decision not to extradite to Mozambique, because both of them are decisions. So we are remitting these decisions to you so that you can make a decision. Now, the legal question that arises, my lady, which is important, is which factors must the minister take into account? And this brings us to the concept of then to this notion of ex nunc and ex nunc. Is it ex nunc or is it ex nunc, my lady? So ex nunc, must the minister take the factors as of now? When I say as of now, that is when he makes the decision, or must he only look at the factors which existed as at the time when Masuta made the decision, or as at the time when Chang was arrested at OR Tambo International Airport? What then the law tells us is that a decision maker takes into account factors ex nunc, so the factors which exist as at the time he makes the decision. So all what your leadership has to look at in order to see whether Chang still enjoys the immunity that Chang 1 judgment speaks about is to look at what happened after Chang 1 until when the minister made the decision on the 23rd of August 2021. So I'm just going to point out to your leadership the new factors that happened, which the minister was obliged to take into account, and which were not then before the court in Chang 1 by way of affidavits or or under oath. So firstly, we know that there was an issue of immunity of Chang, which enjoyed in terms of the Mozambican law, which immunized members of parliament from prosecution as long as they're members of parliament. The Chang 1, in fact, if we just look at the judgment in Chang 1, you will see that the judgment was handed down on the 1st of November 2019, but it was argued on the 16th and 17th October 2019. At that time, Chang was still a member of parliament. What was said to have happened with Chang at the time was that he has applied to parliament so that he renounces that. But then because of that immunity was given to him by virtue of him being a member of parliament, you'll see that the court in Chang 1 rejected that because it doubted whether you can really renounce something which is given to you by statute. In this case, you are a member of parliament, you are immunized. It's like yourself being a judge, and then you are immunized then from being prosecuted for certain things that you do whilst you're a judge. But whilst you are still a judge and you say that, well, I'm renouncing that. So the question that will arise is, well, can you even competently do that? So that really was the issue. But what is not the issue, and I don't see it to be even an issue here, is that when you are no longer a member of parliament, you don't enjoy that immunity. And that has not been contested even by the applicant here. The only thing that they're raising with you, my lady, is that they're saying that, well, we don't know whether, although then you lose the immunity, we don't know whether you will not be allowed to raise a defense that you cannot prosecute me for those offenses because I committed them whilst I was a member of parliament. But what is not in dispute, even on the applicant's own version, when they were now filing the supplementary founding affidavit after they've read the record, is that Chang is no longer a member of parliament. He's no longer a member of parliament because in October, when Chang 1 was being argued in court, Mozambique was conducting national elections for parliamentary elections where Chang was not a candidate. And Chang then, membership of parliament ended automatically when a new parliament was installed or sworn in. So there's no question, my lady, that Chang is no longer a member of parliament. The only debate that is raised by the applicant is that, well, but we don't know whether then he can't still be immunized for the offenses that he committed whilst he was a member of parliament. But the answer is self-evident, my lady, that if the immune that you get is by virtue of the membership of parliament, the moment you are no longer a member of parliament, then you no longer have that immunity. But one cannot stop any accused person from raising any defense that he wants to raise before a court of law, because courts of law are the ones which know how to deal with matters applying the law, and they'll only apply then the law. What the Auditor General, what the Attorney General has said under oath is that Chang no longer enjoys immunity because he's no longer a member of parliament. He lost that immunity automatically when he ceased to be a member of parliament. And that can be gainsaid because that is not an issue that has to do with the record, my lady. It has to do with evidence. So on what basis will your ladyship accept the say-so of Ms. Nicole van der Venter, who is just an instructing attorney, who doesn't practice in Mozambican law, against a qualified attorney who is an attorney general in Mozambique? And that is said under oath. So that's where then we say pluscon events then comes in. So unless if your ladyship rejects the version put under oath by the Mozambican Attorney General that Chang no longer enjoys immunity as against then the say-so of an attorney from South Africa. So that's why we said that your ladyship will still have to assess the probative value of the version that is put in the affidavit by a South African who does not then profess to be qualified in Mozambican law, and who does not even have a confirmatory affidavit then from anybody from Mozambique, even anybody then from the applicant themselves. And we say that the applicants, all of them are members, are citizens of Mozambique, and they live and reside in Mozambique. They know then how the law operates, but they've chosen not to put any version before this court at all. But the lawyer who is qualified in Mozambican law, who is also the Attorney General, has put under oath these facts, and to say that Chang no longer enjoys immunity. So the leadership then is simply to resolve this issue to the extent that it constitutes dispute of fact on Plascon events. And hence in our heads of arguments, you'll see page 13, paragraph 35 of our heads of arguments, we quoted with approval paragraph 26 of the SCA judgment in NDPP versus Zuma. Well, it was simply a restatement in Plascon events, although refined on how courts must deal with motion proceedings, that the court cannot deal with motion proceedings based on probabilities. So it's not a question of probabilities, but where that dispute of fact, then the court then will have to look at what the respondents say and reject the version of the respondent only if it is far-fetched, untenable, and forced to be rejected then outright because it is not credit-worthy. And that really then has remained the test as it has been espoused in Plascon Evans Pains versus Van Riebeck Pains. And that has always been our law. So that is going to be determined by virtue of what the respondent's version then is. So, my lady, then on the question of immunity, we now know that when the Chang 1 was argued, Chang was a member of parliament. After that, Chang lost his membership of parliament, and by virtue of that, he stopped to be a member of parliament, and the immunity that he enjoyed actually fell away by the wayside. Of course, I don't want to go into the opinions that my sister dealt with, because she was dealing with them in the context of rebutting the allegation by the applicant that, in fact, the minister then ignored opinions which said that Chang still enjoys immunity. But anyway, then those opinions have shown that they were not saying exactly that at all. But in fact, then I want to say myself, even if they were saying that, that was not going to be binding on your leadership, but they do answer the question of rationality in the context of the Simelane judgment, which is a DA versus the President of the Republic of South Africa, that the minister had 5 opinions in front of him, and those opinions have not contradicted the decision that he has taken. And so we say that, in fact, it lays to bed the criticism that was laid. There was a very lengthy submission by Mr. Du Plessis relying on the Simelane judgment, and which, in fact, on the facts, then seem to contradict exactly what happened in practice, that the 5 opinions that were submitted to the minister were saying something different to what Mr. Du Plessis is saying, and in fact, they were considered by the minister, and the minister did not go against them. But nothing prevented him from going against them, or unless he gives reasons. But in this case, because the opinions were not saying something that he did, we're not saying the opposite of what he did, then he doesn't have then to provide justification for that. He is obliged to provide justification if he disagrees with those opinions. That we accept, and that's exactly what the Constitutional Court said in the Simelane judgment. So insofar as immunity is concerned, my lady, we said that that has become a moot point, and that's why it was correct then when Ms. Purifin then Jones said that we say that it's a moot point. We're saying it's a moot point in that context, that it became a moot point the moment Chang lost the membership of the Mozambican Parliament. So that leaves us now then to the issue of the warrant of arrest, my lady. The warrant, you see that warrant. Then first, let me start with the international warrant of arrest. The international warrant of arrest is case line 0671. What I'm interested in that warrant of arrest it is the date, of course, that is the date of the warrant. You'll see, my lady, at page 0672. You see at the bottom there, it says, abide by, it says Maputo, January 29, 2019, the Honorable Justice, and then it mentions the name of the Honorable Justice there, and then you can see the signature there. Now, the importance of the date is that the warrant of arrest existed before Chang 1, but because then the court had found on the first ground of immunity, the court did not have to scrutinize the warrant of arrest, which is here. So then that is now something that is before you, my lady, then to consider. But our submission in respect of the warrant of arrest is the following. You have to ask yourself, was this issued by an honorable justice in Mozambique? If it was not, is the end of the matter. But anyway, the applicant are not saying that it was not issued by a Supreme Court judge. That they're not contesting. What they are saying in their papers, they are saying that, well, this warrant was issued whilst he was enjoying immunity. And so, and when he was a member of parliament, they say we do not know if it is still valid when he's no longer a member of parliament. But a warrant of arrest is a warrant of arrest. And a warrant of arrest is to arrest a person so that the person can appear before a justice of the court. It is the justice of the court who will determine whether that warrant is unlawful or not. It is not for the applicant to decide whether the warrant is valid or not. It's for the court in Mozambique. It's not even a South African court which can pronounce on a warrant issued by another justice in another country, a sovereign state, to say that that warrant is not valid. What the court has to accept is that there is a warrant of arrest issued by a judge in a foreign state, in which which is Mozambique, and that is the end of the matter. The validity or thereof will be dealt with by the court of Mozambique. We know, my lady, that warrants of arrest have been issued against people many times, and then people go to court and they get those warrants set aside. And those warrants, they don't get set aside because the prosecution wanted them to be set aside or the police wanted them to be set aside. They are set aside because it is an independent judicial officer who looks at the facts and looks at the law and make a decision, and that decision must be respected by everybody. So the same as we do in South Africa, when we say that the rule of law must be respected, and when judges have made decisions, we must respect them. We must then reciprocate and say that the people of Mozambique are entitled to have their own laws and even their criminal law, and that they must deal with their matters in the manner in which then their law permits. And if judges then make decisions, the people of Mozambique must respect those decisions.
Sorry, Mr. Macari, I can't. Just a moment. Sorry, Mr. Macari, something went wrong with. Well.
But I can still hear you, my lady.
Okay, you can hear me, right?
I can hear you clearly.
All right. So the last point I heard was that Mozambique is entitled to interpret its own warrant.
Yes. So yes.
This court can't interpret that warrant.
Yes. So what I'm saying is that the Mozambican judiciary is entitled then to interpret and decide on the validity of a warrant that has been issued against a person and make a decision based on that. And if then it makes a decision, that decision must be respected by the people of Mozambique. And I was giving an analogy here that in South Africa, we subscribe to the rule of law, that the courts are the final arbiters of disputes, And the courts are the ones who are going to determine whether a warrant of arrest for a person is valid or not, and whether a person must be released then despite that the warrant is there. So that's really then what the point I was making. So I was saying that the only time that the warrant can be questioned is if it is placed in dispute insofar as that it was not issued by an authorized officer. If, for instance, a warrant then was issued by somebody who works in a hotel, then one will say that, well, this warrant can't be valid because then it has to be issued by somebody who's authorized. But here, it is a warrant that has been issued by a Supreme Court judge, and it requires that he must be arrested. And of course, Mozambique can arrest him in South Africa because it will be in breach of international law and respect of sovereignty of other states. All what Mozambique can do is to enforce this warrant the moment he touches on Mozambican soil. And Mozambique will not arrest him and put him in jail indefinitely. It must arrest him so that he can appear before a justice of the court, and it is the justice of the court who is going to determine the further detention of Mr. Chang. The same way as it happened in South Africa when he was arrested at OR Tambo International Airport, he was taken before a magistrate. It was a magistrate who made a decision that he must remain in detention pending the decision by the minister to extradite him. So it's the same principle and nothing untoward about that. But then we have been criticized then for bringing to the attention of the court another warrant of arrest. But then that criticism, my lady, is baseless, because what we are saying in our affidavit is that to show that Mozambique is serious about prosecuting Chang, even after the Chang won, it submitted a mutual assistance request to South Africa with an inquiry that took place before a magistrate in respect of a separate matter of bribery and fraud, separate in the sense that it is separate from the hidden debt scandal. And as a result of the information that was gathered from that inquiry before a magistrate in South Africa through the mutual assistance request, another warrant of arrest has been issued against Chang. So if then Mozambique was not serious about prosecuting Chang, why will it go to such length to have Chang back in Mozambique? Can it be, on the facts really be suggested, that Mozambique goes to this length to have Chang back in Mozambique in order then for Chang then to walk free? So we submit that that is far really then from any evidence that one can gather from the record. So your lordship simply has to accept that there is a warrant of arrest for Chang, but the Auditor General, the Attorney General has said under oath that the procedure is that Chang, of course, will be handed over to Interpol South Africa by the South African authorities, so that Interpol South Africa must hand him over to Interpol Mozambique. But the moment he touches on Mozambican soil, he's going to be arrested and held in detention for him to appear before a justice of the court. And there is no reason then to doubt an Attorney General whose specialty is in criminal law and his or her duty is to prosecute offenders. So there is no reason really then to say that just on the plus one evidence, just on the plus one evidence test. So the issue of the warrant of arrest is laid to bed, my lady, by virtue of the fact that it is accepted even by the applicant that a warrant of arrest exists, but the applicant are simply seeking to punch holes on a warrant of arrest. But they can't do it here. If they want to punch holes, then they're doing it then before a wrong court. Before this court, there is a warrant of arrest, and before the minister, there was a warrant of arrest. And the minister is not somebody who must scrutinize warrants of arrest which are authorized by people. I had the submission from Helen Suzman Foundation, which seeks to somehow question that why is the warrant issued by a Supreme Court judge? But the absurdity of such submission or questioning, my lady, is to question the laws of other people and the laws of sovereign states. Imagine if our Criminal Procedure Act had a section which says that a warrant of arrest of a person must be authorized by a Supreme Court judge or a High Court judge. Nobody was going to take issue with that because they're going to say, well, that's South African law. But if it is a law of another country, then we want to criticize it. Every country has the latitude and the right to formulate their laws the way they want. They can even say that a warrant of arrest can only be issued by Chief Justice of the country. If then that is their law, then let's respect their law. So then, that actually then, put to bed the issue of warrant of arrest. What remains now then is the indictment. Again, it is common cause, my lady, even on the applicant's version, that there is an indictment, but the criticism is that it's a provisional indictment. Now, this can be disposed of very quickly, my lady. The minister had in front of him an indictment, and that indictment we have explained under oath how it came to South Africa. In terms of Mozambican law, which the applicant can't dispute, is that an indictment can only be served on a person who is on Mozambican soil. And in this case, because Chang is not on Mozambican soil, he's in a foreign country in South Africa, the Attorney General had to make an application for the Supreme Court judge to authorize the serving of the indictment on a foreign soil, which is South Africa, through diplomatic channels. And my lady, you will be knowing that this is not foreign law even to us in South Africa. For instance, when we come to the law of divorce in South Africa, divorce summons must be served on the defendant personally. The sheriff must go look for the defendant personally. I don't know if your leadership is still there. I don't see.
Yes, I am.
Oh, okay, that's fine. Okay.
I'm muting my video because the Wi-Fi is becoming unstable where I am.
Okay, no, that's fine. Okay, that's fine. I just wanted to be sure. No, it's fine.
Yes.
Thanks, Melanie. Yes, no, it's fine. You can put it off then, as long as I know that you're there. Yes. So then the point that I'm making is that the submission I'm making about having to go to court for the court to authorize the unusual service of a process is not something that is foreign to South African law. So I was giving an example with divorce, that in divorce, the summons must be served on the defendant personally. The sheriff must go look for the defendant until the sheriff can get the defendant. And if the defendant can't be found, the sheriff can't simply give the summons to somebody, whoever he or she can get, or just leave them and put them at the door. The sheriff then can't do that. The sheriff will go back to the plaintiff and say that I can't find the defendant. Then the plaintiff must then go to court, to the High Court, for a High Court judge to authorize what we call a substituted service. Either to say that you are authorized to publish this summons in a Sowetan newspaper. And if the defendant ran away, then took a long holiday to another country, then the judge is authorized to say that I'm authorizing that this must be done by a dictal citation, then they call it the dictal service, something like that, in a foreign country. It's not something unusual. So here, the indictment was authorized by a judge in Mozambique so that it can be, through diplomatic channels, served here in South Africa. And so the indictment exists. It sets out what the offenses are, and we are set under oath. The moment he arrives in Mozambique, we're going to make sure that he is arrested, and then the indictment is going to be read out to him before then a judge, and then the judge will authenticate it, and then proceedings will start in accordance, again, not in accordance with South African law, in accordance with Mozambican law. So then that now takes me then to the last point, my lady, which is remedies. Remedies in a matter like this will be informed by Section 172 of the Constitution. You will see that Section 172, 1B, it empowers this court to make an order which is just and equitable. So the interest of justice, so it means that the court will be faced with whether to extradite if it goes by way of substitution, whether it extradite Chang to Mozambique or to the US. Whilst, of course, we are reluctant to say that the judge must do that because of what was said in Trancon, that courts should not proclaim to have superior wisdom over other arms of government. But we are persuaded somehow by the submissions made by our learned colleague, Ms. Baloyi, that there may well be other factors which the court may not be in a position to consider, because then they fall exclusively within the domain of the minister or the executive to make a decision. That substitution may be maybe at this stage not appropriate, given the fact that in Trancon, the court says that the court must substitute where it is a foregone conclusion. But in this case, you can see that we are far from what you can call a foregone conclusion. And understandably so, Mr. Du Plessis did not press on you or make submissions on substitution except to say that he stands by what he has said in the heads of arguments. And I'll say that the reason why he says so is because there was nothing for him to argue substitution, especially when it is clear that this is not a foregone conclusion. But in any event, we cannot ask your leadership to make an order that Mr. Chang is extradited to Mozambique, because that decision has already been made. So the only way then for Mr. Chang to be extradited to Mozambique, if your leadership accepts our submissions in respect of that Mr. Chang does not enjoy immunity, there is a warrant of arrest, there is an indictment, then your leadership will simply dismiss the review application and the minister's decision will stand, and then Mr. Chang will be extradited to Mozambique. But as far as that the court substitute the decision and say that he must be extradited to the United States of America, we say that there are no facts that are of such a nature that it is a foregone conclusion. So your leadership shouldn't even go there. So your leadership will have to then consider a remittal and, of course, maybe with specific direction of what the minister must look at. But we say, my lady, that that can only happen if your leadership has made definitive findings on immunity, warrant of arrest, and indictment. We don't agree with the submission by Helen Suzman Foundation that your leadership does not have to make findings about these three important material factors, because these are the factors which determine whether the minister had the power in the first place to make the decision that he has made. If the court finds that he had the power to extradite him to Mozambique because Chang does not enjoy immunity and there is a warrant of arrest and indictment, then this court must say so. It is not something that one has to shy away from, because it is a matter that involves the liberty of a person who continues to stay in South African jail in perpetuity without any idea of what is going to happen about his future. He needs to know, is he going to be prosecuted in the first place, or is it going to be this litigation one after the other whilst he's serving jail in perpetuity in South Africa? So the court can't promote that. So one way or the other, the court has to bring finality to this matter. And the only way the court can bring finality to this matter is to tell us whether is Mr. Chang enjoying immunity or not. And so that we can know what to do. And so that Mozambique can know what to do. But at the moment, Mozambique has nothing more that it can do when it knows that it has issued, there's a warrant of arrest issued by a judge, there is an indictment which is issued, and the man does not enjoy immunity anymore. So we submit, my lady, that if for whatever reason you are not with us and you want a remittal, we'll say that you must do so with specific truncated timelines to the minister, so that he can make a decision either within 10 days or 15 days. Of course, then he may call other than the interested parties to make further representation if they want to do so. He can ask questions for clarity and so on, but the decision must be made within the shortest time possible so that this thing can come to an end. But we submit, my lady, that the applicant have clearly made no case whatsoever on any of these three material factors. I don't have to deal with the other grounds of a review, as I've pointed out that the principle of priority based on which state has started first doesn't apply according to the SADC protocol. And in the issue of bad faith, it is just gratuitous, as it has been pointed out by my colleague, Ms. Malloy. Of course, it is unfortunate that, I mean, an NGO that is supposed to play a very important role in Mozambique, then to make sure that it holds government officials accountable, that it will be making such gratuitous remarks then of bad faith. And so it's just unfortunate, but then, I mean, your leadership will simply not take that any further, because there are just no facts then to support anything of a nature of a bad faith. Insofar as the delay by the minister, what we can say, my lady, is that it is Mozambique which actually went to court to compel the minister then to make a decision. So Mozambique is the one that went to court to compel the minister to make a decision because it was too long. So that again is an indication of how serious Mozambique has always been, because Mozambique said, we have been prejudiced. We have then 19 other accused persons who are supposed to face trial, and there is no decision that is made about Chang. And it was on the basis of that ultimately then the decision was made. But of course, then a failure to make a decision does not give rise to the reviewability of a decision that is subsequently made, because an aggrieved person always has the remedy to approach court to compel the decision maker to make a decision. But finally, my lady, can I just, although it has nothing much to do with Mozambique, to just touch on the submission that was made with regard to, I mean, the engagement that the court had with my colleague, Mrs. Sibaloi, about the minister made provided reasons after the decision. My lady, the answer, although this is a political decision and not administrative decision, but PAJA will assist us in that regard. So I'm not saying that PAJA applies, but I'm simply saying that it will provide some guidance on whether a decision maker is obliged to make a decision with reasons at the same time. We say that there is no provision in law which obliges the decision maker to make a decision and with reasons immediately. But the decision maker is obliged to provide reasons for his decision on request. And you'll find that in Section 5 of PAJA, especially 1, it says, any person whose rights have been materially and adversely affected by administrative action and who has not been given reasons for the action may, within 90 days after the date on which that person became aware of the action or might reasonably have been expected to have become aware of the action, request that the administrator concerned furnish written reasons for the action. So it is clear from the reading of 5 sub 1 that the decision maker is not obliged to provide the reasons when he makes a decision. He is obliged only to make a decision. But if he's requested to provide reasons, he must do so. And then you'll have seen in the notice of motion that the applicant specifically requested that the minister must furnish the record and provide the reasons. So if the reasons were not given together with the decision, which in this case was not, the minister then has to give the reasons as soon as possible. If the date has not been given, or if it was PAJA, he will do so within 90 days. But because this was an urgent application, he had to do so within the shortest period possible. Hence, then he provided those reasons on the 31st of March. So, sorry, the 31st of August. So there's nothing unlawful about that. It is perfectly how the legislative scheme is anticipated, because otherwise it will mean that on each occasion one is to give reasons. Let's use an example of a judge, because the good thing is that as lawyers we're able to reflect on ourselves and give examples about ourselves. A judge is not obliged to give reasons in any decision that the judge makes. But upon request, a judge is obliged to give reasons. And you can't say that because the judge gave reasons after the order, these reasons actually are an afterthought or maybe then the judge is given reasons after leave to appeal has been filed, then you say that, oh, this is an afterthought because the judge has looked at my grounds of appeal. It doesn't work that way. It is just impractically possible for a decision maker to motivate for every decision that he makes. Because other decisions, then you may find that the parties then don't even want reasons. Like orders. The judge has made an order and then nobody then wants the judge to give reasons. So we say that Section 5 of PAJA will provide guidance to the court that a decision maker, in general terms, is not obliged to give contemporaneous reasons, but a decision maker must, and that's an obligation, give reasons upon request. If it is a PAJA decision, must do so within 90 days. If the matter is urgent, must do so as urgently as possible. And that's exactly what the minister did here. So I just want to then to respond to that because it is a legal point. But otherwise, my lady, these are our submissions, and we submit that the application should be dismissed with cost. Just for the sake of time, my lady, we have criticized the applicant for making speculative assertions and allegations. These are not without merit. I'm just going to refer your leadership to the founding affidavit, the passages that your leadership will then have regard to. In the founding affidavit, it will be page 11 to 15. First, then that is now, sorry, it is page 02. So 02-5, paragraph 21, you'll see there, my lady, that the applicant, at that time, the applicant did not even have the benefit of the record or the reasons. It says, more specifically, the grounds on which the FMO relies to review the minister's decision are: the minister decided to extradite Mr. Chang to Mozambique, notwithstanding the absence of an arrest warrant for Mr. Chang in Mozambique. B, the minister failed to consider appropriate the fact that the US was the first country to request the extradition, but this one is fine, they have dealt with it. The minister failed to consider the Mozambican request was made in bad faith. I've dealt with this one. The minister failed to consider South Africa's international legal obligation. Well, they have dealt with that in the hedge of arguments. The minister failed to consider the interest of justice when deciding to extradite Mr. Chang to Mozambique. So that then we've dealt with. But then the point is, when the grounds of a review in the founding affidavit were predicated on the assumption that there is no warrant of arrest, when the record was filed, then the supplementary affidavit sang a different tune. Now it's no longer that there is no warrant. The ground now is that the warrant is invalid. So that's how then it changes. And then in respect of immunity also, you'll see that what is said in the founding affidavit under page 02-12 of the founding affidavit, paragraph 50 to 53, is that Chang is immune, and when the record is produced in the supplementary affidavit, now the assertion is that it is not clear whether he still remains immune despite that he's no longer a member of parliament. And your leadership, you'll find in the supplementary, then in the supplementary founding affidavit, paragraphs, that will be page, so in the supplementary founding affidavit, then it will be page 11-15, page 11-15, paragraphs 39 to 43. You will see there that what the deponent simply states now is Mozambique has said that Chang was not immune, and then so therefore it must not be believed now when it says he's immune. But obviously, then the court must simply look at factually whether then he's immune or not, given that it is common cause, is no longer a member of a parliament. And what they say in these paragraphs 39 to 43, it is simply to say that it is not clear FMO is concerned, but we say that that's not how motion proceedings are to be run, especially when the onus rests on you. He who alleges must prove. And then you say that you must leave it to the court for the court to guess which way then, will be the better devil to go. So the court must decide on the facts. Did you put evidence to show that he's immune? Did you put evidence to show that there is no warrant of arrest? Did you put evidence that there is no indictment? So that is really then how the court then decide motion proceedings. And if you did not, and then the answering affidavit of the respondent has substantively dealt with those issues, then plus one events that must work against the applicant. Madari, we submit that this to us is not a matter which enjoys BioWatch. Well, of course, ordinarily then it should enjoy BioWatch. The court in Chang 1 has said each party must pay its own cost because it understood the importance of the matter. Whilst we, of course, are not happy with the applicant, the manner in which it conducted itself, particularly the gratuitous allegations of bad faith, which are not based on fact, it is really on that basis that we say we're seeking cost, but otherwise then they weren't going to seek cost against an NGO. But the cost issue is the discretion of the court, and we leave it at the court's hands. But otherwise, we say that for all of the reasons that we have proffered during my oral submissions and the heads of arguments, we submit that the application be dismissed. As a court, please.
Thank you, Mr. Makari. I've got no questions for you. We're going to take a 10-minute adjournment. I want to see if I can do something about my Wi-Fi connection.
As
so
a court,
we'll start just after 4:30.
As a court, please.
Court adjourned. Right, are we ready to commence, Mr. Du Plessis?
Thank you, my lady. It has been a long day, my lady, and I'll attempt to be as concise as I can, but recognizing, of course, that
you have to answer all the issues raised.
Yes, my lady. My lady, fortunately, in many respects, and I'm going to be dealing with our learned friend Ms. Boloy's arguments first. The matter has considerably, it has been considerably made easier by 15 concessions that we counted, my lady. The first concession is that our learned friend accepts that the minister's decision is subject to scrutiny, and we accept that too. What we didn't hear a word from, though, is the authority that I referenced in Similani, and that's been approved in the Nurser case. We didn't hear a word about any of that. The second concession, my lady, is the applicable legal framework. Our learned friends accept that there are these international duties, but we didn't hear a word about the way in which those high duties mean for the court, as Chang 1 highlighted, that there needs to be punctilious compliance with those international duties. And we didn't hear a word from our learned friend about what I said were the 5 reasons for why there were high risks and that the minister would have been on red alert. You remember I started off speaking about that, my lady. We didn't hear a thing about any of those. We take them to be accepted as well. The third concession is, my lady, is that our learned friend said that if the minister didn't have regard to any material factor, then it is fatal. And we'll come back to see how it is fatal in a moment, my lady. Our learned friend then went on to speak about, in that respect, there being 2 states here, both with interests, Mozambique, which has been burdened with loans that have been withdrawn, and the United States, where there's harm to American investors. We didn't quite understand where the point was going because, of course, those are irrelevant competing reasons. The reasons for the United States request versus the Mozambican request are entirely irrelevant. It's clearly not for this court to choose between the respective crimes of the requesting states. And that's why also, with respect, it was an entirely irrelevant exercise for our learned friend Mr. Makari from Mozambique to give us a long exegesis on each of the requirements under the Extradition Act and to tick off each of them, because of course that's not what's before, my lady. You're not being asked to tick off each of these requirements and to choose between the 2 states, my lady. Our learned friend Ms. Baloy then seemed to be criticizing us because she suggested that FMO and she said the HSF are unashamedly expressing their preference for the United States of America. You may remember that, my lady, as though that was something to be criticized about. Well, what our learned friend has forgotten is that that is the minister's preference too. And it's Mr. Van Heerden, the Chief Directorate for International Relations preference. It's also the preference of the Deputy DG for Constitutional Development and the Acting Director General, Mr. Jeffrey, and the Acting Director General and the Deputy Minister of Justice, Mr. Jeffrey. All of them, together with Mr. Lamola, the Minister of Justice, all of them have the same preference. And they signed an approval in that respect in the July memorandum, lady. So it's no point to criticize us. Those are the same views held by very senior ministers of state and officials who have put evidence before the court or had their evidence put before the court, and there's no explanation at all for how they've now, through the minister, attempted to walk away from it. Lady, the minister, through Ms. Baloy, also argues that we didn't speak to the first-in-time principle, and Mr. Makari also criticizes us for not having dealt with that in argument in detail. My lady, I did so, and I expressly said we stand by everything we've said in our heads. I was attempting to be respectful of the time that I knew was going to be a difficulty for today, and not least of all because of some of the bounces that I was having to field with lots of delays incurred on account of that. My lady, so let me just make it palpably clear. We stand by all of those submissions. They're set out in great detail in our heads of argument at paragraph 178 onwards. I won't go through them now, my lady. The Minister's Council also then said that their primary response to our immunity point, they say that is the FMO has not referred to any facts from which it appears that Mr. Chang enjoys immunity still. And that is buttressed by what was said by the Minister in their heads at paragraph 33.1. Lady, with respect, that is rather unbelievable given the contents of the memorandum. And the Minister simply invokes Mozambique's bold assurances that Mr. Chang does not enjoy immunity to justify his decision. Again, given the very strong evidence before him compelling him not to do that, that is irrational. Lady, then comes the fourth concession out of the 15. The fourth concession rather, I should say, from Ms. Baloyi was that I accept that it's a killer point if the evidence shows that he enjoys immunity. And I'm hoping I've written her words down correctly on each occasion. I don't want to have misconstrued her. But I think she said, I accept that it's a killer point if the evidence shows that he enjoys immunity. And at that point, my lady asked, well, isn't the test different? You said, is it not equivocal that he has immunity? And with respect, my lady has the point on the head. That's the killer point entirely. The test is simply whether there was any equivocation in any of the evidence about his having immunity. It's not that we had to show that he had immunity. It's not for the FMO to have shown that and to have reached that level of standard. It's simply enough if the evidence before the minister was that it was not equivocal that he has immunity. Or rather, that it is not unequivocal that he has immunity. If there was any equivocation, then that's the test. My lady, the fifth concession by learned friend said she accepted. She said these words, the minister accepted that it is not unequivocal. The minister accepted, those were her words, that it is not unequivocal about him having immunity.
Yeah.
Game over, my lady, with respect. Nowhere in his affidavit does the minister say that he has immunity. That was the next point by Ms. Baloyi, our learned friend, said that nowhere in his affidavit does the minister say that Mr. Chang has immunity. Well, that's not so with respect. We should emphasize again here that in his answering affidavit, parroting the fifth opinion, the fifth and final opinion, the minister accepts that Mr. Chang has immunity for crimes relating to his mandate, said expressly. And our learned friend read from the opinions at some length, and she attempted to, and I say this with respect to her, read the best of those and to give your ladyship a view, her view, it appears, either her view or what she then said were the experts' views of the opinions that weren't disclosed to the court. So it's palpably not evidence before, my lady. It's from the bar, it's in respect of opinions that they didn't disclose, and it's our learned friend attempting to give the best reading possible, and I understand why, but an attempt to give the best reading possible of those opinions to try and suggest that quite obviously there was a clarity of mind that the immunity question was unequivocally resolved for the minister. But it clearly is not the case, my lady. The opinions need to be looked at again, and I'm afraid I'm going to just have to pick out some of them, my lady, because it's unfortunately the case that when one does this, we do skip over some of the important bits. And the July 2020 memorandum, and I might just start, my lady, right at the beginning of that July 2020 memorandum. It's case lines 06-205.
Right.
My lady, it's important to start at the beginning and then to turn over the page 06-206, and I'll tell you why, because we heard an argument from our learned friends to say, well, this memorandum never emphatically said that there was an immunity problem. And it wasn't really advising the minister about these immunity problems. Well, my lady, look at 06-206, and you'll see under the very first paragraph, purpose. The purpose of this memorandum is to notify the minister of the orders made by the magistrates, Kempton Park. And then under 1.2, request the minister, should he approve, to sign an order in terms of Section 11A of the Act for the surrender of the accused to either the USA to stand trial on charges or to the Republic of Mozambique. I pause there, my lady. The drafters of this memorandum knew that they were going to be weighing up for the minister and asking the minister's approval around a number of opinions and a number of background facts and a number of relevant material to approve one way or the other. And my lady, if my lady turns to the back of that memorandum, it's 06-240. Sorry, before you go there, sorry, my lady, 06-238. And this is enough for me to say. Before I read what's said at paragraph 11, I'll remind my lady, our learned friend, Ms. Baloyi, attempted to give a revisionist reading of the opinions, to explain her view of what the opinions said, and how, in fact, the opinions in numbers of ways, according to her, helped the minister to come to the view that immunity was not a problem in Mozambique. Well, my lady, have a look. 06-238. The conclusion. In light of the above, my lady, when my lady goes back to look, you'll see that the above includes a discussion of all of those opinions and a referencing and a summary of them. It says, in light of the above, and taking the specific under-mentioned factors into consideration, it is recommended that the minister issue an order in terms of Section 11 of the Act for the surrender of Mr. Chang to the United States. And then, my lady, at the top of the page, 06-239, you'll see. And I hadn't had a chance in the argument to highlight this for you, my lady, but you'll go back when you read the papers to see that one of the points firmly made against us by the minister was that there was no risk. He said this under oath in part A of the application. He said there was no risk, he said, that the accused, Mr. Chang, wouldn't ultimately be able to be extradited to the United States, even if he was first sent to Mozambique. And you'll see there, my lady, at the top of the page, should the accused be extradited to Mozambique, he could not, on completion of his trial, be extradited by Mozambique to the United States, as this is unconditionally forbidden by the Mozambique Constitution. The US, however, would be in a position to extradite on the other way around. Lady, and then at the bottom, under 13, it's recommended that the minister issue an order in terms of Section 11A of the Act for the surrender of Chang to persons authorized by the authorities of the United States to reprieve them. And my lady knows that is completed at 06-240, where that recommendation is underlined and everybody signs. So, my lady, with respect, one doesn't need to get through an effort to try and overcome the parallel evidence rule and a whole range of other principles in our law, which tell you that if something is confirmed and approved by a minister and who says, I've read all of this stuff, I've looked at these opinions, and I've come to the view that there's a problem, one of the big problems obviously being immunity, then that's enough for the court with respect. The minister's alternative response to our immunity point, my lady, is to say that none of the legal opinions considered by the minister conclusively conclude that Mr. Chang enjoys immunity in Mozambique. That was the secondary gist of her argument with respect to her, but that's simply not so. The fifth opinion, especially, the minister in his answering affidavit, they accept that Mr. Chang enjoys immunity for crimes relating to his mandate as a minister, whatever that may mean. But in any event, at the very least, my lady, they raise considerable doubts. Going back to my lady's question, isn't that really the test? Isn't that really the killer point? If there is some equivocation, if there's some concern, some risk, or to use the language of the Simelane judgment, if there's a prima facie doubt about these relevant material facts, well, then you don't extradite a man back to a place where those doubts might come to fruition, such that he doesn't stand trial for $2.5 billion worth of corruption. And so that's why we say they raise considerable doubts, and to the effect that they then raise those doubts, then obviously the minister could not agree that he be returned to Mozambique. And that is why, with respect, my lady, we again say, and we commend it to you repeatedly because it's just such an obvious point, that is why so many senior officials of our government recommended the very opposite, that he be returned to the United States. Now, my lady, our learned friend objects, Ms. Baloy, to the suggestion that the minister has, suggestion by us, that the minister has selectively attached himself to the fifth opinion. You recall our learned friend said, well, it's not just the fifth opinion that is attached to. But, my lady, the minister's answering affidavit, one goes to 06189, and I'm sorry to have to take you there, but it is necessary. Lady, 06189 is where you'll find the minister putting up in answer the July memorandum. My lady, do you see it?
I see it, yes.
My lady, you'll see, I read it to you in my opening address or my main address. I said, paragraph 31, you'll see there, the minister puts up the memorandum. She then references the legal opinions. And note there, my lady, just note, I state in the reasons for decision, I took into account legal opinions. Then look what he said. The legal opinions include opinions from experts in Mozambican law. The legal opinions are not included in the record because they're privileged. will be made available to the court should the court so require. And then the opinions state the following. Now, my lady, I'm going to have to now ask you, just give you the references, to write next to these paragraphs where they parrot from. They all parrot, with exception of, I think, one paragraph, the 5th Mozambican opinion. 31.1 of the minister's answering affidavit, my lady, is a verbatim, literally a verbatim reference to paragraph 10.2 of the 5th opinion, including the grammatical infelicity of speaking about in lieu. We weren't making the point pejoratively, my lady. We're making the point that it's interesting that the same grammatical infelicity is included in the minister's answering affidavit as is found in that opinion. My lady, 31.2, I haven't been able to find where that comes from. I think it comes from the 2nd opinion, my lady. So paragraph 31.2, I think, comes from the 2nd opinion. In the time available, I've not been able to find it. But, my lady, I have been able to find that paragraph 31.3 of the minister's answering affidavit parrots paragraph 10.3 of the 5th opinion. My lady, paragraph over the page 06-190, paragraph 31.4 parrots paragraph 10.7 of the 5th opinion. Paragraph 31.5 of the minister's answering affidavit parrots the second or the last paragraph of 10.2 of the 5th opinion. And, my lady, paragraph 31.6 parrots paragraph 10.3 of the 5th opinion. So, my lady, we didn't take the point cheaply. We took it because we were concerned that the minister appeared to be preferencing selectively one of the opinions. And I've just shown for you, my lady, that's exactly correct. So our little friend can keep telling us that we make points without substance. And we've had that criticism directed at us quite personally and unfortunately. We have made this on the basis of the evidence that is before, my lady. So the killer point is that the minister parroted the 5th opinion, and that opinion says that he's immune. We don't know whether these acts would be covered as official acts, my lady. It's never been alleged, cannot be. And you have to read paragraph 10.5 of the 5th opinion with paragraph 10.2. I'm not going to do it now, my lady, but I'll just ask you to please take a reference here. When you read paragraph 10.5 together with paragraph 10.2 of the 5th opinion, it makes it clear that Mr. Chang is still immune for acts relating to his mandate that he committed or for acts that were committed when he was a minister. We asked the question, and we asked it quite pertinently. That would be problematic. It would mean that his immunity covers him for what he did. It might mean that he stepped down now and that he no longer has immunity for acts going forward. But we don't know whether it doesn't have him retrospectively covered for the acts he committed when he was a minister. My lady, I learned from Mr. Macquarie tries to use the point about my lady's immunity as a judge. Use that as an example. You've got immunity right now, my lady, for whatever you're doing sitting as a judge. If you step down, you lose your judicial immunity. Going forward, you would lose it. From the day onwards, you no longer can claim that I've got robes as a judge and I have immunity for the acts I commit. But, my lady, the question is whether you are covered by immunity for the acts you committed at the time you were a judge, backward looking. And that's the problem. So, my lady, we simply don't know. And it's never explained by the minister. It's never explained by anybody with respect. Mozambique equivocates on all of the immunities. And again, I don't have the time, my lady, but in our supplementary finding affidavit, we have set out in great detail how Mozambique has equivocated on what immunity actually exists. Our learned friend, Mr. Macquarie, attempts to come and try and explain to the court, I'll explain why it's all irrelevant anyway, but he attempts to come and explain to the court where the immunity position really is. And he tries to, with respect, quite adventurously, he tries to use Plascon Evans to say, but now we've given the answers as Mozambique on behalf of a minister of state in another country impugned in another court. Okay, that in itself is obviously not permissible. But the point is, even Mozambique's arguments are equivocal. They equivocate all over the place on this, lady. And I'll just give you, with respect, it's in our supplementary finding affidavit, paragraph 33 onwards at case lines 11 to 15. I'm not going to take you there, but, my lady, it sets out this equivocation in detail, and that's not answered by Mozambique. My lady, finally, from our learned friend in respect of the opinions in the July 2020 memorandum, there's one aspect that our learned friend never answered at all, never dealt with at all, and that is she never explains where in the record the minister explained his approval of that July 2020 memo, or any further reasons for moving away from it. She can't, because the minister never does it. There's nowhere in the record where the minister explains how it is that he could have signed that document in July 2020 and how he moved away from his position, whether he spoke about it with his other colleagues, whether he had deep and meaningful meetings with them about it, whether he was worried about the fact that his position was changing. We just don't know. And our learned friend never explains that at all.
Well, how can she if there's nothing in the affidavit to explain it?
Well, quite a question, my lady. Lady, then on bad faith. Our learned friend, Ms. Mboloyi, says that, well, it's all in the past. It's all in the past, the stuff about bad faith. And yes, she accepts that this minister at one point in Chang 1 said that he believed that South Africa had been deliberately misled. But she says that's all in the past. She says we now have to look at the relevant facts now. And with respect, and while we're using the word gratuitous, we are gratuitously criticized. She says that bad faith is a construct, that was her word, by FMO and HSF. And she accuses us of reading selectively. Well, with respect to her accusations are incautiously made. Her effrontery is misguided, my lady, because have a look at paragraph 9.5.5 of the fourth opinion as it has been summarized in the record. It's at case lines 06-234.
Right.
My lady, our learned friend read from that page, but she tellingly skipped over paragraph 9.5.5. This is the second opinion. She made much of this. Sorry, my lady, this is the fourth opinion. It's the fourth opinion in the July memorandum by what she said from the bar was a Mozambican expert, but let's take her at her word for now. And my lady, but this Mozambique expert, she didn't read what this Mozambique expert had said at 9.5.5. The extradition request by Mozambique was made mala fide and contained false, incomplete, and misleading information. So, my lady, it's not correct to say that we have, as FMO or HSF, constructed a bad faith contention. It's the minister's own opinions. And I'm sorry to have to say this ad nauseum. He approved it. He signed. He agreed. So when we come to the court and we say that there was bad faith, lady, we've got perfectly good grounds for doing so. Our learned friend also said that we have constructed the argument that Mr. Chang would prefer to be extradited to Mozambique. It's a very serious accusation to make against one's colleagues, to say that we have made up the argument that Mr. Chang would prefer to be extradited to Mozambique. Our learned friend said there's no substance to that claim. My lady, if I may read from case lines 231, case line 6-231, paragraph 7.7. So my lady got it.
Got it.
Right at the bottom of the page, my lady. This is now from the second legal opinion. From it appears, if you see at 7.1, my lady, 06-230, you'll see 7.1 on the left-hand side of the page. The brief to the mentioned advocates. So it appears that there was more than one advocate on this brief. South African Council, we have to accept. And then if you look at the bottom of page 06-231, paragraph 7.7, you'll see it's also very clear that Mr. Chang would prefer to be extradited to Mozambique, as he may be of the view that Mozambique will not be able to effectively prosecute him. So we didn't construct the argument, my lady, that Mr. Chang would prefer to be extradited to Mozambique. That's in the minister's record. Then, my lady, our learned friend says delay is not a valid ground for review. Our learned friend, Ms. Beloya. Well, it is, because of decisional rationality and procedural rationality. My lady asked me the question. I said we rely on both. And we've set this out again in detail in our heads as to the rational process. I'm not going to read it. It's at paragraph 172 of our heads onwards, where we deal with delay. And let's just snapshot the point, my lady. It's quite incredible. A man is languishing in prison. He's waiting to know where he's got to go. A July memorandum of 2020 says he should go to the USA. If that had been acted on, he would have been in the USA by now, months down the track with a trial. Instead, we've got nothing. until out of the blue, there comes a decision in August of this year that he's going elsewhere. Of course, that's procedurally suspect. One needs to ask the question, what happened? And when you get the record, there's absolutely nothing explaining what happened from the July 2020 memorandum until the decision is taken on the 17th of August this year. So no, it is procedurally irrational, it's opaque, and it lacks all, unfortunately, the requirements of accountability, responsiveness, and professionalism that Section 237 of the Constitution places squarely on the minister's head. He's the Minister of Justice, let me remind you, Malay. So then there is the sixth concession. The minister now agrees, my lady, Ms. Baloy, that there's no valid warrant. So all Mr. Makari's efforts for Mozambique to try and explain where the valid warrant is, they go absolutely nowhere, of course, alongside that concession. And then, my lady, there is concession 7. Our learned friend Ms. Baloy said that the July 2020 memo, she says, it was prepared for this case. Sorry, not the July 20 memo, the 31 August reasons. Excuse me, my lady. Our learned friend, I've mistyped what she'd said, but she said the reasons document, the 31 August reasons document, she said, it was prepared for this case. And she accepted, she has to accept that because, of course, the heading of that reasons document references this case and this case number. And my lady, she then goes on and asks for condonation. And our learned friend said that she thought that I had suggested that they should have brought a proper application for the condonation. And they should have done so through some form of interlocutory. But no, that's not what I said, my lady. I never said that there needed to be a full-blown application. We all recognize the importance of this case being heard as quickly as possible before, my lady. What I said was, my lady, is that the answering affidavit is where they've tried to get condonation. But that the answering affidavit sets out a woeful effort for condonation. And there's not been a single answer by our learned friend other than to try and again claim that urgency is an all-embracing answer. There was no answer given by our learned friend, Ms. Baloy, to each of the 4 points that I've made for why condonation should not be granted. I've set them out in my argument. I stand by them, my lady, they're in our heads. All our learned friend was able to do ultimately is to complain about the urgency of the case and to blame the state officials who were compiling the record. But my lady, when I come to the issue of costs, I will highlight that that is simply
you
not...
also have to touch on remedy again.
Yes, I will.
I've received a message that this meeting will only last another 5 minutes. I think I'd better phone Sophia and tell her to extend the time.
Well, my lady, it depends, I suppose, on how badly you really want to continue hearing from us.
No, I want to hear this to the end. Oh, I don't know now. Let me phone Zaki.
Thank you, my lady.
This is a way of extending the life of the meeting. Right, they're going to extend the time.
Thank you, my lady. So, my lady, I was pointing out that in respect of condonation, we stand by everything we've explained for why there should be no condonation for the minister's belated putting up of his 31 August reasons, which he only gave to us on the 2nd of September. And as I stressed, and there's simply been no answer to this from our learned friend, Ms. Baloy, this is not an ordinary litigant. This is the Minister of Justice. And yes, he is represented by a fulsome team of senior counsel and junior, and he does have a senior state attorney, and he knows the importance of this case with respect, my lady. So we stand by all of those, and my lady will read them in her own time. Lady, concession 8, our learned friend, in an attempt to try and explain a bit further why the minister's reasons should come in, our learned friend said, these were her words, perhaps we should have given a fuller explanation than inadvertence. Those were her words, my lady. Well, absolutely. She's conceded that they needed to give a better explanation, and they certainly did. The ninth concept, and they certainly did not, sorry. The ninth concession is this, my lady. A learned friend said, you can accept that the 31 August reasons document was prepared after these proceedings were initiated. Concession 10, my lady, is a learned friend says...
Oh, sorry, before you move away from that point, I think Mr. Makari said, well, it doesn't have to be contemporaneous if you compare it with an order being given in court and then reasons later.
Yes, and you try to invoke Padger, my lady, but with respect, that misses the point.
Yes.
Yes, it misses the point entirely. The point is, you as a minister have to give reasons, and they have to be contemporaneous with the record that you file. And there obviously has to be a connection between your reasons and the record. There can't be a disconnect. As the US Supreme Court says, we don't need to be naive here. Otherwise, what happens is you, as the judge, are going to be looking at a decision which does not bear a rational relationship with the record. And we know in this case, lady, there's a palpable disconnect. There couldn't be, it's difficult to imagine a case where there could be a greater disjunct between the minister's reasons on 31 August and the July 2020 memorandum. And it helps little to say, oh, but Padger says you can get reasons later, or a judge can give reasons later. Well, my lady, let me give you an example of how that would be. Assume for my lady that you had a bench book in which you'd already written down what you thought your reasons were just after today's judgment.
Sorry, sorry, Mr. Duplessis, I just want to see what my clerk says. Zaki? Yes, all right. Yes, because of the recording. Okay, thanks, Zaki. Don't forget to send me. Okay. Right, it's done. We've got another hour.
Okay, thank you, my lady.
It won't be necessary.
No, we hope so, my lady. I hope to try and finish in the next 10 to 15 minutes, my lady. My lady, then there, where was I? Sorry, my lady. Concession number 10. Our learned friend said, the minister should have submitted an affidavit that explains the signature on the July 2020 memorandum. But there is no such affidavit. Lady, that's a fatal concession. We just don't know why there was a change. And our learned friend accepts that there should have been an explanation, but there wasn't one. Concession number 11, our learned friend said, you must look at the document critically, given the date that it was signed and approved. So my learned friend, quite correctly, these are concessions that are well and honorably made, realizes in light of our own jurisprudence on you may not make up reasons after the fact, and that the Supreme Court in the United States, and I never thought I'd want to repeat what I'd said earlier about this, milady, on that basis, but it really is important to remember that court said the reason we want contemporaneous documents that bear a relationship with the reasons and the record that was taken at the time by the decision maker's decision is because we want to be sure that there hasn't been an adjustment of the posts and that there hasn't been what the court called litigants trying to keep up with the new reasons. That's exactly what we've had to do in this case, my lady. Concession number 13, my lady, was our learned friend saying, in response to a question from my lady, shouldn't the reasons be contemporaneous? That's what my lady asked. Our learned friend said, yes, there should be. If they had been, we wouldn't have been in this controversy. Concession 14, my lady, was, when you look at the record, the reasons must appear from the record. A learned friend said that. When you look at the record, she said, the reasons must appear from the record. She went on to say, well, if you look at the record, the factors listed by the minister are not extraneous to the record. In other words, she's attempting to say that the 31 August reasons are somehow drawn from the record. But they're not so, my lady, they're not. The reasons don't explain or even mention the July memorandum. They don't mention or explain the approval. They don't even mention the arrest warrant problem. And the record's reasons are quite the opposite. The reasons, and the only ones valid and permissibly before this court and signed by the minister, are reasons that he be sent to the USA. And that's why, with respect, Mr. Makari's invocation of Padger is wrong-headed. The point is that you must read the reasons together with a record, the reasons cannot be different to those contended in the record. And with respect to him, he's entirely missed the case law. And the point of our case law, I've referenced the High Courts, the full court, the Supreme Court of Appeal, the Constitutional Court. They emphatically say the reasons that you look at must be the reasons that are extant in the record, nothing else. And then there's an overall concession, number 15, by a learned friend for the minister. Ms. Baloyi said she seemed to have to accept this in her argument towards the end. She says there is a possibility, she said, that the minister's decision may be set aside, if anything, she said, on the warrant point and the fact that there were no contemporaneous reasons. And those are great reasons to win on, with respect, my lady. We'll take those. Then there's the question of review and substitution.
Yes, deal with that.
My lady, perhaps I was going to say, let me deal with it. I was going to, my lady, in fact, it would make more sense, if you don't mind, my lady, if I turn very quickly to Mozambique's arguments, because...
Yes, okay, yes, please do that. Yes.
So, my lady, in response to Mozambique's arguments, we can be short. There are really 4 points to make. The first is, and we say this with respect to them, it's utterly irrelevant information and evidence that they place before this court, because as the court said in Chang 1, and it said this at paragraph 35 of the judgment, after it had a look at a whole bunch of additional submissions that were being made by Mr. Chang and by Mozambique, my lady. It came to this point, paragraph 35. It said, this has no impact on the minister's decisions, as they must be evaluated on the basis of the facts as they were at the date on which the decision was taken. So, my lady, whatever averments Mozambique now makes on oath to try and counter our factual averments, they're all irrelevant because they were not before the minister. And they don't get to put them before the minister by what our learned friend attempts to do through a Pascon Evans point. It goes nowhere. My lady, for another reason it goes nowhere, and that is because my lady will be very concerned, of course, to try and do what our learned friend suggested, which is effectively to weigh up all of the evidence, one way in favor of America and the other way in favor of Mozambique. You'll recall our learned friend this box-ticking exercise going through the statute. And it was a very long exegesis, and it was interesting in numbers of respects, but it's utterly irrelevant because my lady is not being asked in any way to try and make a determination for one state versus the other at all. My lady is not going to be weighing the factors. And my lady certainly wouldn't be weighing the factors in favor of a self-interested state who, alongside Mr. Chang, is wanting to ensure that he is returned to that state. And it would run counter to the most damning evidence, which is the only evidence before the court, and that is the July 2020 memorandum. So it helps nothing for our learned friend to try and convince the court that if you just believe the Attorney General of Mozambique, everything will be fine. And this court should order that he be returned to Mozambique because there are a whole bunch of people who are really worried about what's happened to Mr. Chang and the money that disappeared out of the country. My lady, those are the very material factors that have been weighed deeply after considering all of the submissions, including Mozambique's, in that July 2020 memorandum. And at the end of it, and signed by all the relevant senior officials and government ministers in our state, they said they don't believe that is the right outcome. The right outcome is the other way. My lady, so it's irrelevant for that second reason. My lady, it's also dangerous with respect because Mozambique has not openly played its cards with the minister. My learned friend, Mr. Cohen, highlighted this in his address to you, my lady. Mozambique, in its answering affidavit, for the first time, presented another arrest warrant. And that arrest warrant, my lady, is set out in detail in our heads of argument. I'm not going to take you there, obviously, that we just don't have the time, but you know the passages. It's at it's at paragraph 126 of our heads onwards, where we highlight that this new arrest warrant is in fact devastating for Mozambique's case. And obviously, there's no explanation on its version why it didn't disclosed this warrant to the minister at the time that it was making its request, or thereafter. My lady, there's a fourth point. Our learned friend asks, he says, why would Mozambique spend time and money to investigate? Why, he says, Mr. Macquarie says, would all of this energy be put into trying to get a man back to Mozambique if they weren't really serious about it? That's hypothecating, my lady. You don't win cases by hypothesis. You win it by evidence. And the evidence is that people had asked that very question, and they decided in the July 2020 memorandum that it wasn't good enough. So it's also irrelevant for that reason. But our learned friend then goes on, and again he makes an unfortunate accusation against it. He says, well, why distrust? Why do these people, FMO and the Helen Suzman Foundation, why do they distrust Mozambique and make these gratuitous bad faith claims against Mozambique? And so far as that point goes, my lady, he even uses it later, half-heartedly admittedly, but to suggest that we should be denied a biowatch protection when it comes to costs. So let me unfortunately, again, we'll just read it for my lady very quickly, but it is necessary to stress this point, because our learned friend, to complain that we are somehow making up a bad faith point or making gratuitous accusations against them, unfortunately again misses what a legal expert, a Mozambican legal expert, according to Ms. Baloy, in the fourth legal opinion, said to the minister at paragraph 9.5.5, case lines 06-234. I read it to you earlier. I'm going to read it again, my lady. The extradition request by Mozambique was made mala fide and contained false, incomplete, and misleading information. That's why we're saying it, not because we're gratuitous. So, my lady, if I might then turn to the question of review and substitution. Lady asked, with respect, the perfectly correct question, isn't the minister's decision effectively entrenched? Hasn't he already taken it and made his position palpably clear, concretely so? And we say that is correct. He has shown no signs, my lady, of being willing to consider the alternative. Had he not opposed, then it may have been different, my lady. But his very strenuous opposition here suggests that he will not properly reconsider the decision. And he has committed himself in the answering affidavit. He has committed himself in the answering affidavit to sending Mr. Chang to Mozambique. He hasn't said, this is a tricky issue. It's come before the court. I've got competing requests. There's a rationality challenge to what I've done. The record will show whether I've been right or wrong. The judge will decide. He doesn't do that. He comes here and he doggedly says, I'm sending him to Mozambique. I've got good reasons to do so. And he does that in the face of never explaining how he's moved away from the approval of the July 2020 memorandum. And in that respect then, in our heads of argument, we have dealt in the final section on remedy, on why we say that remittal is not appropriate in this case. And it starts, my lady, at paragraph 191 of our heads. My lady, we know the factors, so does my lady. We've highlighted at paragraph 24, and let me just stop. There was a suggestion, before I go further, by Mr. Macquarie that, oh, but Mr. du Plessis never went through the idea of substitution because he doesn't seem to have faith in that argument. Well, with respect, my lady, that is simply not so. Mr. Macquarie has too little faith in me to have made that submission. I said it very clearly to the court that time was an issue, and I said our submissions are there in our heads and we stand by each of them. And I also said, my lady, we don't know properly from the heads of argument filed by our learned friends because they came in last night. The minister's heads came in just before 11 o'clock last night. I'll tell you honestly, my lady, I was fast asleep. And Mozambique's heads of arguments came in at 12:05 last night. I was even faster asleep at that point. So quite correctly, and having driven to where I was this morning, I haven't had a chance properly to have a look at their arguments. I said I wanted to hear what they had to say about this, and then I would deal with it in reply. So, my lady, this court is in as good a position. The extradition decision-making process has now run its course twice. The court has before it all the evidence that was before the minister. There are no new facts. There's nothing about this particular case, institutional nature and its competence that prevents Malady from making the decision. Why do I say that, Malady? Because we know that the decision has already been made by the minister, and there's no countervailing evidence. No new reasons, no walking away from the July 2020 memorandum, in which 2 ministers of state, as well as the senior international legal advisor for the government and the Deputy General of Justice, and there's somebody else as well, I've forgotten them all now, lady, but there's a string of very impressive people who've all come to the view that a Section 11 approval needs to be given by the minister. That was what was recommended and was approved for extradition to the United States. So it's a foregone conclusion, my lady. There's only one proper outcome, and that's revealed by the memo and the failure by the government, as Ms. Baloy correctly concedes, that perhaps should have filed a supplementary affidavit to explain why the minister changed his mind. They elected not to, my lady. They elected not to. So they've left, and as Justice Crichler said in Dlamini and Skittercut, my lady will know the case, litigation involves hard choices. Well, they made a hard choice. They made a hard choice not to file an affidavit by the minister. And so my lady only has no reasons whatsoever after July 2020, and then the approval that says go to the United States in the evidence. My lady, delay. The minister's not explained the delay in making his decision. The court cannot know if remittal will imply another 2 years of detention for Mr. Chang without trial. This unexplained delay and the prejudice to Mr. Chang, it's ironic that the FMO is criticized for not liking Mr. Chang and so on, but we're actually concerned about the fact that there needs to be finality here for Mr. Chang. And the outcome, which is most in the interest of justice, is that in the absence of any explanation for the delay, and because of the prejudice to him, it strongly speaks in favor of this court ordering substitution on the evidence that it has before it, which says go to the United States. Now, our learned friends then complain about us gratuitously saying that the ministers manifested incompetence and bias. Well, it's always difficult to have to say that as an advocate in a case. We thought about it carefully, my lady, but for all the reasons that I've explained, we think it unfortunately has to be said that in this context, the minister's record, the manner in which the minister has chopped and changed his views, and the failure by the minister to explain why that has happened, unfortunately does leave us with a view that the minister is lacking in the ability and the independence to be able to make a proper decision here. And we're confirmed in that respect, my lady, by the fact of how the minister has opposed this case. He was on notice to look out for immunity after this court's judgment in Chang. He failed to do so. He was advised in the clearest terms, and he accepted that advice, that Mr. Chang is immune in Mozambique, or at least that there was a risk of that. He then later decided to ignore that advice for no reason. And his 31 August reasons and his answering affidavit do not engage with those material concerns raised by his advisors and lawyers about Mr. Chang's immunity. So, my lady, we're unfortunately in the position where, by virtue of the minister's own evidence, he is still not seriously engaging with these very real issues. Worse, he's attempting to, in his answering affidavit, give new reasons for why he says Mr. Chang should go to Mozambique. No, my lady, in that situation, I'm afraid to say that that is the definition of a closed-minded approach, and which does not show a fair competence to deal with these issues squarely and forthrightly. My lady, the case that we've called in service here is a famous one. It's Cash Paymaster Services. And it's a decision which has been endorsed in this division by His Lordship Mr. Justice Murphy in Tantush. We've referenced it in their heads, my lady. And in that context, and I only know about Cash Paymaster Services, my lady, because I was in Tantush. But in Tantush, His Lordship Mr. Justice Murphy agreed with an argument that we had made, which was to say that if an administrator is challenged, like here, and the administrator had different choices available to him, like here, and the administrator, instead of saying, look, it's a difficult thing for me to do, I had to decide between competing requests, I might have made a mistake, you court decide. When the decision maker instead comes to court and steadfastly, rigorously defends his decision to the hilt and insists that his decision is right, come what may, despite the evidence, despite the problems in his evidence, then unfortunately, said the court, that suggests a perception of bias. As his lordship, Mr. Justice Pickering in Cash Paymaster said, and it's quoted by Murphy J. and Tantush, he said, the perception of bias might quite possibly be enhanced by another factor which appeared to the court to be somewhat unusual. Unlike what normally occurs in review matters of this nature, the board has in this case offered extremely strenuous opposition to the review proceedings. I've great difficulty in understanding why. He explains all of the points, my lady. And he then says, this type of strenuous opposition gives, regrettably, the suggestion that they're not entirely independent and disinterested, he says at the end of that passage. And we say those findings apply with equal force here, my lady. The minister does not and should not have any interest in where Mr. Chang is extradited. He's an independent decision maker. He's meant to be effectively adjudicating between these two competing requests, and his opposition speaks to a lack of impartiality. So, my lady, those reasons are why we say that substitution is appropriate in this case. My lady, then if I might turn to the question of what our learned friend said about this very quickly. Our learned friend, Ms. Beloy, accepted that the minister, so in fact there was a 16th concession, I hadn't counted this last one, but our learned friend accepted that the minister has committed himself in the answering affidavit to going to Mozambique. And our learned friend then said that if my lady was minded to go down the path of substitution, you would have to deal with what she said were, and I wrote her words down, objectively verifiable facts. Well, we agree. My lady, they are. They're objectively verifiable. You can believe the minister, deputy minister, senior legal advisor on international law, deputy DG for justice, that he must go to the United States of America. There is not a single reason, objective, subjective, dreamt up, speculative, it just doesn't exist for anything the other way. We set that out in our heads in detail, my lady. So, lady, then if I might turn to the issue of costs. The minister says that costs must be determined today. Again, litigation involves hard choices. That was their election. They wanted it to be determined today. I'll come to that election in a moment, my lady. And the minister has, and we with respect say, taken the somewhat surprising point that they have blamed us for raising the issue of costs in our replying affidavit. My lady, we've put up a chronology. That's why I did it early this morning. I thought that now my lady's unfortunately going to have a chronology, which sets out all of the procedural steps in this case, in which my lady will be able to read alongside our replying affidavit, where we've set out in great detail why, for, again, a number of reasons, the issue of punitive costs arises for my lady to determine.
Right.
My lady, it's at, I'm going to just suggest to you that you keep it open for now. It's in case line 16-7. I'll come back to it in a moment, my lady. But our learned friend has, with respect, surprisingly criticized us for taking the issue of costs in the replying affidavit. When you look at the chronology, my lady, of what happened in this case, of course we took it in the replying affidavit. Just think about it backwards. When did we get the minister's reasons? The 31 August reasons. They were given to us on 2 September, on the very day that our answering affidavit, our supplementary finding affidavit was due. We, in the supplementary finding affidavit, found out that there was the July 2020 memo, but it hadn't been included. When were we going to raise that, my lady? You know what we attempted to do is we attempted to assume good faith on the minister's part that when the minister didn't put it in the record, it wasn't going to be something that the minister would attempt to rely on. But lo and behold, in the answering affidavit, my lady, in the answering affidavit, the minister puts up the July 2020 memorandum. So where else were we going to deal with it other than in reply? And by the time that had happened, my lady, including a whole range of other problems, which I'll highlight when I take you through the reply points on punitive costs, by that point, of course, we had to then say, this is a minister who unfortunately is deserving of a punitive costs order. So, my lady, our learned friend Ms. Beloy says, well, we're just complaining about the record being late and that it was badly filed. And she says there's no authority that she's aware of for punitive costs for a record that's late and that's badly filed. I'm going to pause, my lady. That's only one of the problems that I'm going to be highlighting for you, but I want to deal with this argument by her that says she's not aware of any authority for punitive costs for a record late and badly filed. The reason I want to start with that, my lady, is this. It is a huge complaint that we have, and if what I'm about to read to you from our Constitutional Court confirms why punitive costs can be awarded just for that reason, then my lady will be well advised to know that with all the other reasons I'm about to tell you, punitive costs would certainly be applicable. My lady, it's a judgment in Public Protector by the Constitutional Court. Yeah. And we refer to it, my lady, in our practice note. It's in our practice note, my lady, page 5 of the practice note. It's Public Protector versus South African Reserve Bank, 2019 ZACC. And I apologize, my lady, that I hadn't put that case up on the short authorities list, but
I'm aware of the case. I'm aware.
You're aware, my lady, but my apologies for not putting it up because, unfortunately, as of last night, I didn't know that the issue of costs by the minister would be something that they wanted us to determine today. But in that case, my lady, at paragraph 237, this is what the Constitutional Court said. And I'm just going to read it to you, my lady. Regard must be had to the higher standard of conduct expected from public officials. This conduct included the numerous misstatements, like misrepresenting various things under oath, and failing to disclose material meetings, and then obfuscating the reasons for them and the reasons why they had not been previously disclosed, and generally failing to provide the court with a frank and candid account of the conduct in preparing the report. The punitive aspect of the cost order therefore stands. Earlier, my lady, at paragraphs 186 to 7, the justices held as follows, and this is particularly on the record. The record that was produced by the Public Protector was thrown together with no discernible order or index and excluded important documents. The Public Protector is wrong when she claims that she filed the entire record. She didn't. She omitted pertinent documents from the record, some of which were only put up for the first time as annexes to her answering affidavit in the High Court, and others which were disclosed for the first time in this court. Public Protector's failure to include these documents in the record or to account for this failure properly stands in stark contrast to our heightened obligation as a public official to assist the reviewing court. Now, lady, I want to pause. That's the Public Protector. She has duties, the Constitutional Court has stressed them. Above her, as an exemplar of the constitutional duty that is upon public officials, is the Minister of Justice and Constitutional Development, or the Minister of Justice now, and Correctional Services. So the facts of the matter are instructive here. The Public Protector failed to file a complete record. She didn't take the court into her confidence. It was obvious that she'd omitted important documents and events in her account of her decision. And when she tried to explain herself, she was contradictory and evasive. And that justified a punitive cost order. That's the first decision, my lady. Our learned friend says she doesn't know of any authority. There's the Public Protector decision. The next decision, my lady will know this well. I think anybody that's ever had to deal with a record will recall what His Lordship Justice Scutts said in the Fire Chem case, my lady. My lady, it's paragraph 42 of what he said there. And he in paragraph 42, my lady, I'm just going to quickly try and find it. I'm sorry, I had it earlier. It's gone for now, my lady. It doesn't matter. What is important is, and my lady will remember this, at paragraph 42 of that judgment. Perhaps I should just give my lady the, my lady, what I'll do is, sorry, just to assist my lady, I'll put both.
Is the name Fire Chem?
Yes, my lady. It's Premier of the Free State versus Fire Chem.
Okay.
My lady, and I'll put both of these judgments up on case lines for my lady, the Public Protector one and the Scutts JA judgment, my lady. At paragraph 42, and I'm just speaking from memory now, my lady, but it's a famous passage. He criticizes the state attorney for the way that the record had been compiled. He criticizes the state attorney because there was no index and it was a shambles, and documents had been omitted and that were later included. And he ultimately said that it was justify a punitive cost order. And he has a famous passage where he said, it would have taken a mathematician versed in chaos theory to make sense of this record. Well, we say the same is true of us, my lady. This record was dumped on us at 11:30 at night when it had to be made available. No index, nearly 2,000 odd pages, a whole shambles, no order, no chronology, nothing. Lady, that's not how litigation should work. And you don't say, as we've heard from our learned friend, well, you know, it's tough. We're all working urgently. Lady, we've worked urgently. All of us have worked urgently. You don't file records like this. And the SCA in FireChem said as much at paragraph 42. My lady, I then am going to very quickly say to my lady that it's unfortunately necessary to go through the Minister's conduct in these proceedings as set out in our replying affidavit, paragraph 6, case lines 16-7. And I will do so very, very briefly, my lady. I'll try and do so as quickly as possible. Lady will see it there. We've said that in light of the conduct of the Minister, we are going to be seeking a punitive order against him. And we have attempted to follow the authority of the Constitutional Court in Black Sash. And that's one of the other cases I've referenced in our practice note, my lady, where the Constitutional Court did this. My lady, just to remind my lady, in Black Sash, the Minister of Social Development hadn't properly assisted the court in numbers of ways. And in Black Sash, just like here, my lady, there'd been a full argument. The case had been heard. And one of the parties in that case, Black Sash, I think it was, said the Minister's conduct has been incorrigible, the litigation conduct in particular. And so therefore we asked for a punitive costs order against the Minister. What did the Constitutional Court do? It did exactly what we've asked in this case. It said, we accept that the Minister needs to be able to answer. So we're going to issue effectively a rule saying to the Minister, this is what's being asked of you. If you want to avoid a personal costs order, file something. So that's why we've referenced Black Sash, lady. And these were the accusations or the averments that we'd made against the Minister in the replying affidavit. At paragraph 7 of the reply, we'll see, we said on the 24th of August, the first problem with the Minister's conduct is that the Minister refused to provide FMO with an undertaking that Mr. Chang won't be extradited to Mozambique. As it turns out, the Minister did so while knowing full well that his decision may be susceptible to a meritorious judicial review. I read from the legal opinion, the second legal opinion that he had before him, my lady said, if you're going to be doing this, you're going to be subject to judicial review. He knew that, and despite that, my lady, he was refusing to give us an undertaking. The result of that would have been that Mr. Chang would have been returned to Mozambique had we not come urgently to court. The Minister's refusal to give us an undertaking was evidence that he wanted to put the man on a plane. Second, my lady, when we brought our Part A relief on the 24th of August, the Minister opposed our application tooth and nail. My lady, he even took the point that my attorney didn't have the requisite authority to represent the FMO in this case, in an affidavit no less, not by filing a Rule 7 notice, but in an affidavit saying, we don't think that FMO's attorney has got authority to bring this case. An urgent case where he was about to put a man on a plane and we tried to scramble to get an affidavit into the court. With respect, my lady, incorrigible. Third, 2 hours before the Part A was heard on the Friday, that 27th of August, my lady, the Minister filed heads of argument, suddenly agreeing to provide the undertaking that Mr. Chang wouldn't be extradited. So we'd been forced, we'd been raced to court. We'd had to do everything possible to try and avoid this. And then when we get to the Part A hearing, the heads of argument, following the example of Mozambique, say, okay, no, we recognize that an undertaking has to be given. Fourth, my lady, the Minister was due to file a record of and the reasons for his decision on Monday, the 30th of August. That date had already been shifted from the 27th of August. And the Minister managed to file part of his record, but as I say, at 11:30 p.m. on the Monday, meeting the deadline. He did so by sending FMO's attorneys an email with various attachments. And you'll see, my lady, in the supplementary finding affidavit, we've explained how this was all disorganized. No clear, coherent record, no chronological arrangement. He simply dumped a randomly assorted hodgepodge of documents with various duplicates on this court and us, knowing full well, my lady, knowing full well. Our learned friend has tried to invoke urgency in her favor, you'll remember in her argument. They knew full well that the urgency was on us, and you can bet your bottom dollar, my lady, if we'd missed any of these deadlines, there would have been some suggestion, oh, well, you see now, they've missed the deadline. They're not taking it seriously. So we had no liberty. We had to meet the deadlines. Lady, we met those deadlines, even though they knew that we would have to draft our supplementary finding affidavit just 2 days later. And so we therefore invoke for that grant, the public protected decision I've just referenced and Scott's JA's reference in FireCam, my lady. My lady can read further. If you look over the page, 5th, lady at case line 16.9, we said this jumble of a record was hopelessly incomplete. There was not a single document generated by an official internal to the department, including the minister. Record contained only correspondence and representation sent to the minister. And as we say, my lady, a key document was missing, we know, the memorandum of 27 July. Memorandum was mentioned in an email by department. And when we realized that, we immediately thought, well, the minister is therefore not going to rely on it because it wasn't before the minister. We were wrong, my lady. Just as we were finalizing our supplementary affidavit, at 10:50 a.m. on the 2nd of September, the minister purported to file his reasons for his decision. And I've dealt with that already, my lady. In his answering affidavit, he doesn't answer to our allegations here, my lady, at paragraph 15 of our reply. He blandly says he couldn't return the signed document due to logistical challenges as a result of other work commitments. I've already taken you through this, my lady, when I said why he shouldn't be getting condonation. We stand by all of those submissions. The bottom line here is, my lady, he sat on that. He knew that he had signed it. Either he didn't take the requisite effort to send it across to us, or he was just plainly reckless in the way that he was litigating with respect. A document of that importance in a case where we critically needed it in order to supplement should not have been sent to us in that fashion. 7th, my lady, the minister has, with respect, the gall to allege that we were not prejudiced by his late filing of his reasons. Again, that's explained fully in the supplementary affidavit, and the minister does not and he hasn't answered to those allegations. There's no apology or account for why FMO was pressured into having so little time to consider the minister's reasons at all. 8th, my lady, FMO alleged in the supplementary affidavit that the July 2020 memorandum wasn't included in the record. And so we filed, sorry, my lady, and when we heard nothing from the minister in response about this, we assumed that the minister had agreed with the allegation. In other words, that it wasn't in the record. We were wrong. You'll see at paragraph 18 of the affidavit, my lady. The minister, knowing full well that FMO was not given the memorandum, he held on to it until he filed his answering affidavit on the 7th of September. So from the 2nd of September, my lady, when we said in our supplementary finding affidavit that it had not been included, 6 days later, the minister then delivered up the July 2020 memorandum. And he did so, my lady, when he knew that we would only have 3 days to consider that memo before filing a replying affidavit. Why did he withhold the 2020 memorandum? Well, we know there's a vague reference to inadvertence. It's made by the minister in his answering affidavit. With respect, my lady, we say that's risible. This is the Minister of Justice, no less. And we say this. He's represented by a dedicated attorney. He's got a senior legal team. Each of his officials, he and everybody else knew the importance of that document. To suggest that between them that this conduct was inadvertent, with respect, we say, does nobody any honor. And so this inadvertence, we say, cannot be explained. And the minister refers to the memorandum in his reasons of 31 August 2020. That reference alone should have prompted even an inadvertent official and a high-powered legal team to check whether the memorandum was included in the record. And my lady, do you mind? I'm terribly sorry. I'm just going to put the lights on because it's actually become dark in my room.
So am I. It's getting dark now.
I'll be back in a second. I'm sorry, my lady.
Right.
My lady, and then at paragraph 22 over the page, the 10th reason, you can skip that, my lady. The 11th reason, sorry, at paragraph 24. And we don't say it lightly, my lady, but it's now effectively been conceded by learned friend Ms. Bloy that they should have put up something from the minister to explain why he had moved away from the July 2020 signature that he had appended to the memo. But the fact is, because they didn't put it up, the minister has not taken the court into his confidence. He's not explained the delay in making his decision. He simply says that delay is not a ground of review. He has reluctantly put up the important documents in the record. and he's invoked his legal privilege, to what end we've never been told, to withhold these relevant legal opinions. And he has, as we've said, and we've taken you through this in detail, my lady, is retrofitted those reasons. And so what we have is gaping factual holes in the minister's account of his decision. We're left with a great sense that there was much happening behind the scenes, but this court just doesn't know. My lady, and then 12th, the minister, we've said, has strenuously opposed this application. I've already made those points through the reference to the cash paymaster decision. And then finally, my lady, at paragraph 26, the minister asked for costs against FMO. I mean, he's no doubt aware of BioWatch, my lady, as are his lawyers. He's not made out a case at all for why he says FMO is acting in bad faith. You know the test, my lady. The Constitutional Court in the last year, on my account, I think in 3 or 4 different decisions, has had to reverse the decisions of the High Court and in some cases the Supreme Court of Appeal, where they have not honoured the BioWatch principle. And the court, my lady, I might be speaking out of turn, but I in fact think there was a practice directive sent by the Constitutional Court recently to complain about how the Labour courts are making these orders against litigants not complying with BioWatch. My lady, so it is, with respect, not appropriate to be seeking any costs against FMO. He's no doubt aware of BioWatch, as are his lawyers, as we say. And you've got to make out a case. You've got to say that the litigants have acted in bad faith or that they have acted unconscionably. I mean, in what possible way could it be said that FMO has acted in bad faith and unconscionably? The best we get is Mr. Makari and Ms. Beloy saying that we've been intemperate because we've suggested bad faith on the part of Mozambique. But, my lady, I read for you why we said so. We referenced their own legal opinions that said that Mozambique was acting in bad faith and had misled the minister. So there's no basis for them to have asked for costs against us, my lady. But just think about this too. Here is a Minister of Justice. He's faced with a case where he says he takes his international duties about corruption seriously. My client is a loose assemblage of NGO and civil society groups that are attempting to ensure that the powerful do not escape corruption. And we are being literally told that BioWatch will not protect us. They are going to be seeking costs against this litigant for attempting to do this duty to the Mozambican people, to itself, and to the public interest, and frankly to South Africa's interest, because had they not brought this case, and I stress this, had they not brought this case, my lady, nobody would have known that there was a July 2020 memorandum which suggested, with a minister's signature on it no less, that it's not wise, prudent, rational, lawful to send this man to Mozambique. But on the opposite, it should be the case that he be sent to the United States of America. Had that not been done, had we not brought that case, my lady would not know that, and neither would the public. So with respect, for that reason too, we say it is frankly unbelievable that there would be a request for costs against my client. So my lady, it's important to see all of that context, that behavior in context. We say the minister represents the South African state in this litigation. Our courts have consistently held that the state's held to a higher standard. We know that. The minister, moreover, has teamed up with Mozambique to oppose the application. And on the other hand, FMO is a non-profit organization, cannot even afford to pay its lawyers, my lady. It's litigating before this court, a foreign court, against not just one, but 2 states. And both those states effectively defend the interests of a man of considerable power and influence, accused of industrial scale corruption. The inequality of arms, we say, could not be starker. The opposing respondents in this matter hold considerable power over us. Instead of litigating fairly and properly, the minister attempts to thwart our litigation through what we've called a number of stratagems and to seek costs against us for daring to expose his decision-making. So, my lady, for those 13 reasons, the minister's behavior, we say, warrants censure from the court. Now, my lady, let me just finish off. We said that in reply. Our learned friend, Ms. Beloy, says it's not right that we did so in reply. For the chronological reasons I've already given you, it's obvious why we did so in reply. Importantly, my lady, they could have chosen to answer. They could have chosen to answer what we'd put up in reply. We filed a reply on Friday last week, making very serious claims for personal costs. They knew that those claims were being made. They chose not to, my lady. They made the election not to. My lady, your ladyship knows the decision of Tantush, I think, for another reason. In Tantush, the following was said. And His Lordship Mr. Justice Murphy in Tantush was quoting the SCA in Pretoria Portland Cement. My lady will see this in her own time, no doubt. In Tantush, my lady, does my lady, I'll put Tantush up again as well as one of the authorities, my lady. This is what's said by His Lordship. He said, although these averments were made in the replying affidavits, respondents, strictly speaking, had no entitlement to respond to them. Nevertheless, if the allegations by the applicants were untrue, or if an adequate explanation were possible, leave of the court could and should have been sought to answer them. The respondents did not request to be given an opportunity to deal with these averments. Their failure to do so tilts the probabilities towards the applicant's version in respect of the case. So, my lady, they made an election on Tantush. The averments we've made in the replying affidavit about why we say punitive costs should be awarded stand. My lady, let me finish by saying the following. We nevertheless accept that this is a Minister of State. We nevertheless accept, my lady, that it's an important question here as to whether punitive costs should be awarded. And so, my lady, to the extent that my lady wishes to hear from the Minister, it's entirely in my lady's hands. Then we have proffered the opportunity for the type of order that we have said was granted in the Black Sash case. And we've given my lady the references to the paragraph in the Black Sash case where that's happened. And we've said, my lady, in our practice note, what that relief would look like. Lady, if you look at our practice note, paragraph under relief sought, it's on page 3 of our practice note, my lady. Does my lady have it? Sorry, my lady, you're on mute.
Sorry. Is that on case lines?
Yes, my lady. It's on case lines. I'm sorry, I'm not sure. I just have it printed out. I'm not sure where on case lines, but our practice note. My lady, I'll find the reference for you, but perhaps one of my junior can just quickly.
Filed with something else. I thought I'd seen it.
My lady, it's 1979, if I can assist the court. So it's folder 19, page 79.
Right.
Thank you to Ms. Potiphar-Jones for that assistance.
I thought I'd seen it in the chronology, right.
And just so that my juniors don't feel like they were left out, they've also just sent me the reference, my lady. So my lady, at that paragraph, you'll see that the relief sought is obviously we want the review of the minister's decision, and we want the substitution order, my lady, at prayer 2. And in the alternative to prayer 2, we said the decision should be remitted to the second respondent. My lady, then at 4, and this is directly from a combination of the relief that was granted by the Constitutional Court in Public Protector and in Black Sash. We say the second respondent is called upon to show cause and affidavit on or before 24 September why he should not pay 15% of the cost of the application from his own pocket, alternatively on an attorney and client scale. And then 5, and this is exactly what the Constitutional Court did, my lady. It said the question of costs overall are reserved until conclusion of these proceedings. That makes sense, my lady, because obviously then until we know what the minister said, you wouldn't know what to do with costs. And then we said at 6, alternatively to prayers 4 and 5, the opposing respondents jointly and severally are to pay the applicant's costs. So, my lady, we stand by our submission that the minister has not elected to file an affidavit in response to what we've said about punitive costs. It was an election that he made with his eyes wide open, advised by senior counsel. And in those circumstances, there is no rebuttal under the Tantush principle of anything that has been said by us. And for those reasons, the punitive costs order can be made. To the extent that my lady wants to allow the minister an opportunity to explain himself, then we recognize the importance of the case, and we recognize that the minister may be afforded that opportunity if my lady decides that she wishes to grant that privilege to him, my lady. And that's why we've suggested the orders in the way that we have. My lady, so those are our submissions, unless there's anything else. And I'm tremendously sorry for having gone 10 minutes longer than I'd hoped, my lady.
I think what I'll have to do is extend the order. I'll give you a moment, Ms. Beloy. We'll have to extend the order And then if your attorney can send me the replying affidavit and the practice note in Word.
Yes, my lady.
On Monday.
Yes, my lady.
Mr. Loy?
As your ladyship pleases. My lady, I know it's been a long day, so I do not intend to unnecessarily detain your ladyship, but only to correct certain factual statements or factually incorrect statements, but also to make an observation from what is supposed to have been a reply. My lady, the first correction that I do need to make is my learned friend says that submitted to you that I made the concession that on the issue of indemnity, that the issue is not unequivocal. My lady, I have checked with my junior that in fact, what I said was the issue is not equivocal. That's what I said. And in the event that I may have said not unequivocal, that was not the intention. I wasn't intending to say that. Firmly, the position is that the issue is not equivocal.
Right.
And then the second correction, my lady, that I wish to make is that I made the submission that there is no, or I'm not aware of authority or a punitive cost order for a badly filed record. That's not what I said, my lady. I said for being late, filing a supplementary record. I didn't say for a badly filed record. And then thirdly, I did not accept that the minister committed himself to Mr. Chang going to Mozambique. I didn't make that commitment, that concession. And then further, my lady, and perhaps this is in fact quite important. My learned friend mentions that has referred to a chronology that was filed this morning. Until that chronology has not been served on the parties, and until my learned friend mentioned it, I wasn't even aware that he has filed a chronology, or his attorney has filed a chronology. So whatever is contained there, my lady, I only make the point that it should not be considered to be admitted, the correctness. I haven't seen it. I haven't had the opportunity to look at it, so it should not be considered as having been.
Just mean that I must go and check, for example, item 19, 2 September 2021, applicant supplementary affidavit.
Yes. Well, my lady,
can't your junior check it and then you can let me know on Monday?
We can do that, my lady.
Because otherwise I've got to go through the record.
Yes.
To look for whether an answering affidavit is on page 06-10.
Yes, my lady will do that. And lastly, my lady, it's simply to make the observation that in fact what my learned friend has done in 1.5 hours, which is pretty much as long as when he made his submission, is not only to reply, but in fact to make substantive submissions that he chose not to make initially. And so we couldn't respond to them. On the issue of substitution, the remedy, and the issue of costs. These are submissions that he's making for the first time that he has made. I do not intend to hold your ladyship any further on this, but simply to make.
You made your submissions on substitution.
I've made my submissions.
And I think it's reply, based on those 3 aspects of immunity, yes, the warrant, and so on. Yes. I thought you dealt with it fully.
My lady, on both the remedy and the cost, I mentioned this only to the extent that he may have referred to or made submissions that I didn't have the opportunity to deal with in my submissions because I couldn't have anticipated them. I make only the submission for that purpose, or at least make the reflection for that purpose, my lady. As your ladyship pleases.
Right, thank you very much. So now I must make this order. Miss Goodifin-Jones.
Apologies, my lady. I do not have a right to reply, but there is one factual question that I must correct very, very quickly, please, which is the submission by my learned friend for the minister that the HSF's affidavit was only filed on Tuesday this week, the 14th of September 2021. My lady, that is not factually correct. The affidavits were served on all parties, unsigned, last week Wednesday, and a signed copy was sent to them all last week Thursday. My attorney has uploaded onto Case Lines in folder 24 the emails reflecting the service of those affidavits on all the parties. My lady, it seems like a small thing, but just to please correct that submission.
Right.
My lady, I do accept what my learned friend says, if that's what happened, and perhaps point out that it may well be that we didn't receive it because, as is publicly known, the Department of Justice had problems with emails. So it may well be that's why we never got those last week.
All right, so that is now resolved. Right.
Thank you, my lady.
In this matter, I'm going to reserve judgment, but I have to make the following order, and I also commend Ms. Beloy for immediately agreeing that the undertaking must be extended. So the order that I make is the following. The undertaking by the second respondent not to extradite the first respondent to Mozambique, which undertaking was made on the 25th of August 2021, is extended until this judgment is handed down. Perhaps the attorney or the applicant can send a draft order through on Monday, and I've already made it an order of court, but just to upload it with the necessary stamp. Mr. Duke.
Thank you, my lady. We will do so. Thank you, my lady.
Right, so the court adjourns, and everybody have a relaxing weekend. It's been a long day, and I'm sure a long week for everybody.
Thank you, my lady. Same to you.
Thank you, my lady. As the court pleases.
Thank you, Judge.